Ladies and gentlemen, the show gets started right now. Or yeah, I'll tell you, weekend live streams are the live streams to make it too. They're the best live streams I do. Ladies and gentlemen, welcome to our weekend review. It's Saturday. It's almost 11 o'clock Central Time, noon Eastern Time. We're going to get things started really quickly. We're going to start off with Judge Simpson, and we're going to move quickly into our Fleischer Forum for yesterday. Ladies and gentlemen, popcorn ready, coffee, get you some cinnamon rolls. We got court coming up in just a few minutes. All right, kids, it's pretty much the cue. Ladies and gentlemen, the weekend review is officially started. Like I said just a second ago, Judge Simpson's coming right up. Amanda, you're never too old to enjoy some court. The court gallery is open for business. I'm looking forward to chat this morning. Ladies and gentlemen, we got a crazy one to start the day with. I know some of you may have seen it, but it's a short block of some Simpson. Then we got about 2 hours and some change with Judge Fleischer this morning. It was going to be a good show. Ladies and gentlemen, let's get ready to roll, shall we?
Strong Future Homes versus Bruce Williams.
Jillian Engen for plaintiff.
You got he's here. Bruce Williams.
Yes. Bruce
Okay,
Williams.
there he is. All right, how much is owing on this?
I have a balance including court costs of $2,477.
Okay, and Mr. Williams, how were you intending on getting that paid?
I got assistance through Hawk.
You have it?
Yes.
Okay, so you've already met with Hawk?
I got somebody that through the program that has filled out the paperwork. They're just waiting for the money to be okay. So which I'm waiting for them to get back with me within a week.
Okay, so you're waiting for somebody from Hawk to get back with you?
Yes.
Okay. Who's working with you to get you into Hawk?
The social worker.
Got it. Okay. So I'll adjourn this out to the 31st, 2025 at 2 p.m. Okay, that's in person. So what you'll need to do is, if you're getting assistance from Hawk and you filed what's called an SER, you need to fill out a rental assistance form. You can pick that up from the court, get it, or the QR code, or look in the chat and it'll give you a link to it. Okay? But I need to have that form by Wednesday of next week.
So I can come in Monday and perform.
Okay, very good. Get that filled out. And then we'll see you next Friday at 2 p.m., okay?
Well, I ain't gonna fall asleep in your courtroom no more either.
Pardon?
I'm not gonna fall asleep in your courtroom no more either.
You're not going to speak in my courtroom?
Fall asleep.
Fall asleep.
Yeah,
Okay, I'll keep you awake. All right. All right, Mr. Williams. We'll see you next week, sir. Then I have Gulfside Lakes versus Goble and Gulfside Lakes versus Salvano. Those matters are dismissed on plaintiff's motion without prejudice. Then let me try to clear up your Evergreen Apartments versus Derek Moore. I think he finally showed up.
Jillian Engen for plaintiff.
Mr. Moore, can you unmute? I don't think he can. We're going to send somebody in to help. Oh, there you go.
Okay. How you doing?
I'm doing good. So you finally found us, right?
Yes.
Yeah, all right.
So I had to come
Okay.
here. I'm not good with this stuff.
What'd you say?
I had to come here because I'm not good with this computer stuff.
Okay. Well, we got you. We got your note, so we waited for you, okay?
Thank you. Thank you.
I
I
figured
went to the
you-
wrong
you-
courtroom.
What'd you say?
I ended up going. I didn't know where I had to go, but I went down to the one down in Ann Arbor. I didn't know.
Oh, you went to Ann Arbor?
Yes.
I'm
I didn't know
sorry.
which one I was supposed to go to.
We're a much better court, right?
Pardon?
We're a much better court. We're more friendly.
Oh, yes, y'all are.
You see? I told everybody that.
I think it depends
Nothing
on
like
the
fishing
day,
for a
Your
compliment.
Honor.
All right. How much is owing on this?
I have a balance including court costs of $1,522.91.
All right. All right, Mr. Moore, how are you intending on getting that paid?
I did the SARS things too, but I don't have my appointment until the 27th next month.
With Hawk?
Yes.
Okay. Is there anything you're going to be able to pay in the interim, you think, or no?
I lost my job and they didn't let, my worker didn't find out on time to let them know to reduce my rent for December. So I had to pay the whole December's rent. So they already put me behind. Then I start paying child support. And then they start
Okay.
taking that out. So it just got me all messed up.
I got you. So how much is his monthly rent at this point?
Let me check. I have this February is going to be 383.
383.
Yes.
All right. But right now you're unemployed, right?
Yes, I get unemployment though, but they give me one check. They only supposed to take out $592 a month, but they give me $362 a month, and then they take $362 the next week. Then they give me $362. But I have to go to Detroit to try to get that fixed. I gotta go to Penobscot building and file something to get it changed. Even though
All right.
I'm only supposed to pay $592, but they're taking out like $720.
Gotcha. Okay. Tell you what. Well,
I can put something in. I do get a check this week. It's only like $360, but I can at least put in 200 something, just so you know I'm not trying to
200. Okay.
something.
You get that this week, you think?
Yes, it should be by Monday. So at least I'll be having it
Okay.
by Monday for sure.
So here's what I'll do. I'll adjourn this out a week, and then we'll to January 31st, 2025 at 2 p.m. That's in person.
Yeah.
So you get to come into the courtroom now that you know where you're going. Okay.
And I got to get the come up here and fill out the paperwork, and I come here to
The
do
paperwork.
Okay.
Right. Okay. And make sure we have that by next Wednesday. What's
Okay.
important, so we're going to need your tracking number from your SER.
Tracking number.
Yes, sir.
Okay. And I got another thing too. This month they charged me $509, but I was only supposed to pay $383. I got the paperwork too.
Are you
Okay.
talking about
Well,
rent, sir?
Pardon?
Mr. Moore, are you talking about your rent you were charged?
Yes.
Yes, they also then they applied a credit of $126.
Oh, okay. I didn't know.
They just had to put in the
Okay.
adjustment, but it probably a statement that you would have gotten probably said that higher amount, that 509.
Okay.
Yes, sir.
Okay.
Yes.
All right. Okay, Mr. Moore, we'll get you straight.
All right.
We'll
Thank
see you
sir.
next week. Get that paperwork in and get that payment into them. Okay.
Yes. Not today. It'll be at least by Monday.
No, I know. Next week.
Okay.
Okay.
All right,
You're good.
Yeah. Bye-bye.
All right. We'll see you then.
Yeah.
Thank you, Your Honor. I'm on the 1 p.m. docket, so.
Yes. We'll see you then. And then this one's a dismissal.
Yes.
Okay. So Legends of Grove versus Sobi Akar. That matter's dismissed. Then,
That one.
yeah.
Yeah.
Okay. Marshall Real Estate versus Gary Ziegler. Is it a recall?
Good morning, Your Honor. Ryan Sweeney appearing on behalf of Marshall Real Estate Group.
Gary Ziegler? Have we tried to prompt him?
He is currently unmuted. I was communicating with him in the chat. He logged out and logged back in, but I told him myself.
Are you in written communication with him at this point?
Yeah.
Is he responding back to you? I don't know what he logged in, logged back off, but we can't hear him. Now he just muted. Mr. Ziegler? Something's wrong with his microphone. It's got to be.
Video minor.
All right. Here's what I'm going to do rather than go through this. Mr. Sweeney, I can't give a default, but I can't also communicate with the defendant. So I'm going to adjourn it out to next week. What time would it be? At 12 p.m. That'd be in person.
Your Honor, if I
Yes,
can,
sir.
my expectation after speaking with my client is that he's going to be seeking or is already seeking assistance, similar to many of the tenants on the docket today. I don't know
Okay.
if we can get a message to him to get that assistance in the same way you've requested the others.
The other folks making sure to get the information here.
Yes,
Okay. All right. So here's what I'll do. I'll adjourn it to the 31st, 2025 at 12 noon. That's in person. We'll let him know because we can communicate him to him that way. And then Ms. Wedling, if you could let him know also to file with the court the rental assistance form by Wednesday, and we'll say where he can get it, see what we can do. Okay? We'll do it that way.
Hello? Hello?
Hello, who are you?
Hello, I'm Gary Ziegler, sir.
Okay.
Sorry.
All right, there you are.
I'm here.
You called in.
I'm
We
here.
got you.
Yeah, I've done, sir, I've done Zooms before. I have no idea what went wrong. That's about as honest as I can get it.
It's okay.
I apologize. I apologize
No, it's all
for
right.
this. Yeah, okay. Yeah. I'm
So
here
here's what
via
we're gonna
audio.
do.
Okay.
Mr. Ziegler, here's what we're gonna do. I'm adjourning this out to next week at 12 noon. You're
Okay,
applying for assistance?
No, I'm not qualified, sir. I've already done all that. I get $1,000 a month in Social Security. I don't have a pension. No, I'm
Hold on
not
a second.
qualified for.
Sir,
Okay.
Mr. Ziegler, have you
Yes, sir.
gone to the Department of Health and Human Services and contacted Hawk?
Yes. Nothing.
What do you mean nothing?
I don't qualify for anything. What I've been told.
your only income is $1,000 a month?
$963 as of the first,
Okay.
correct.
Then something's not right. So here's what I'm going to do, Mr. Ziegler. I'm adjourning your case out to the 31st at 12 noon. Amy is here. Hello, Amy. All right. So, Mr. Ziegler, here's what I'm going to do. I'm going to put you into a breakout room with our court liaison and kind of try to talk through trying to see if there's assistance available for you, okay?
Okay, sir, let me go on record with everybody. I'm a soon-to-be 71-year-old man. I'm partially disabled with side effect neuropathy. I'm virtually housebound. I can do anything.
Right.
I can do anything via Zoom. We'll try it again. But in addition to this, I am housebound. I don't have the money to fix my car. I'm landlocked. I got $800 in the bank.
Mr. Ziegler, we'll
Yes,
work
go ahead,
all of
sir.
that out. I'll let you appear via Zoom next week. Okay, both parties can appear via Zoom. All right.
Okay.
I'm going to put you into a breakout room with Amy, and we're going to talk through and let you guys try to talk through and see what might be available for you. Okay.
Very good. Thank you, sir.
Thank you. Mr. Sweeney, thank you.
Yep.
We'll see you next week, sir.
Have a good day, Your Honor. Thanks.
Yep.
Jarrett Lepick versus Andrew Elliott. And well, Jared Lepick and Jordan Lepick versus Andrew Elliott and Traversia, is it Burrell?
Traversa Borelli.
Burrell. I got it. Okay. And I think I have that. Okay. So plaintiff, how much are you claiming the defendants owe?
We are asking for $21,285. On top of that, we would like to demand for possession and a money judgment for
How much are you requesting in rent?
$21,285.
How much is monthly rent?
5,000 with a late fee of 1,000 not paid after the first, 2,000 late fee not paid after the seventh.
Okay, I can tell you right now, those late fees are illegal. So how much,
That is it. That is in our lease. So this was,
I understand it's in your lease. I'm trying to let you know as gently as I can right now that I'm not enforcing that late fee.
okay. So in your honor, I totally understand. This was not actually intended to be a lease. They had purchased the home and the house sale fell through 2 days before we decided, or before we went into closing, and they had asked to move in. We said, if you pay the mortgage, we drew up a lease based off of them purchasing the home. And this is where we're at. So what happened is then they just stopped paying. And now
how much do they owe in rent?
So it was a $5,000 for 4 months. So that would be a total of $20,000.
And Your Honor, we're asking that February be paid since our lease was a 4-month term. And they have not paid a single payment so far.
And we also missed out on listing the home again because they have refused to not leave.
We've gotten screenshots of proof of funds. We've also been told that ACH has been sent. We received a tracking number at one point that actually never registered with the U.S. Postal Service. And so there's been a lot of like, we're going to pay, and we have yet to receive anything.
Okay, so I can do nothing with February because February is not due. That's the first thing.
If they're still by then, how does that work?
There won't be. We're leaving. We'll be out by the 1st.
Okay, you say you'll be out by the 1st?
Correct, yes.
How come not by next week then, if you're leaving?
I was told in text messages from Jared Lepick that we have until we can finish out the month.
So you'll be out by the 30th? You'll be out by the 31st.
Right.
And you will give them keys?
I can arrange that, yes.
All right, so here's what we'll do, because there are two issues here. One is going to be the money, one is going to be possession.
Mm-hmm.
So I'm going to adjourn this out to the 31st, 2025 at 12 p.m. That will be in person in the court. I'm going to expect that if you have not surrendered the keys, that you will be in court and in a position to surrender keys to the Lepicks at that point. Okay. Then we'll look at what money's there, because then that doesn't run, and we'll figure out what's owed and how that's going to be paid.
I will say we're moving to Seattle, Washington. I will make plans to appear in court in person, but depending on what our living situation is, then it might complicate my ability to show in person. Is there any recourse?
Ma'am, you need to get them the keys.
Oh, I can easily get them the keys regardless.
Okay.
So
they need the keys.
It'll be before the court.
Before what?
Before the court that is being adjourned.
Okay. And then I may permit you to appear via Zoom if you're out of state.
Okay.
But they need their keys.
Of course. Thank you.
Sir, we are also located out of state. We're currently living in North Carolina.
I'm sorry to hear that, but No, I'm kidding. I'm just an old Maryland guy that doesn't like North Carolina, but I really do. It's actually a nice place. Okay, so everybody's out of state. So, ma'am, how are you going to get the keys to them?
They had someone come and give me a new key when they locked me out of the property. There was an illegal lockout that I was subject to. I've got one key that I can return.
All right, I want the key returned.
I can do that.
And then once the key's returned, then both parties may appear via Zoom on the 31st, and then we can figure out the rest of this.
That sounds great.
But I want them to have possession
Of the key.
of the key, which will give them possession of the premises.
Right. Okay, thank you.
All right?
Yeah, we have a manager that they can get the key to.
All right, that's fine. Then everybody can appear via Zoom. So I'll see everybody on the 31st at 12 noon.
Okay, thank you.
Thank you.
Thank you. Is that it? All right, 14A stands in recess.
Ladies and gentlemen, now the Fleischer Forum.
Alex, you ready?
Ready.
Let's roll, nerds.
Did you want to start with one?
Let's roll.
Oh, one was this one.
Well, I got. You ready?
Yes, you
Let's roll. Come on.
Thanks.
Hey.
Lyra's first.
Okay.
Thank you, Your Honor. I greatly appreciate
Are
it.
you also on the co-defendants? Just Ms. Lyra? Okay. Vanegas.
Yes, Your Honor. No, Your Honor. Speak up publicly.
Tristan Vanegas.
Oh, Judge, she's running, late. Oh,
Okay. Are you or James Lyra? Mr. Lyra, you're charged with racing on a highway. And you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, at approximately 12:51 a.m., the officer on-viewed two vehicles at the block of Tomball Parkway, blocking the moving lane of traffic. The officer observed a white Jeep and an orange Corvette line up directly next to each other side by side, and the vehicles accelerated at the same time at a high rate of speed. The traffic stop was initiated of the white Jeep, and the officer made contact with the defendant, the driver, who gave his name and was identified by his Texas driver's license. The other officer stopped the Corvette and detained the second defendant. The driver was positively ID'd by the Texas driver's license.
Do you know how fast they were going?
Your Honor, they do not specify in the DIMS.
Okay. Mr. Lyra, I'm going to find that there's probable cause to go forward with your case. Have you run his license, see if he has it?
Eligible, Your Honor.
Okay. I'm ordering you as a condition of your bond not to participate in this kind of behavior again. If I see that you do, the first thing I'm going to do is I'm going to revoke your bond, put you in jail. The next thing I'm doing, I will take your privilege to drive away from you permanently. Do you understand while this case is over?
Yes, sir.
Open. The ability to not drive in Houston blows. Trust me. Do you understand?
Yes, sir.
Now, you have a lawyer. It's your responsibility to stay in touch with Mr. Clay, and he'll tell you when you have to come back to court. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him, and he'll tell you when you have to come back to court. You pick up a new case, you endanger my public. I only have one place for you. You understand?
Yes, sir.
All right. So I'm gonna have you sign a receipt with Victoria. We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it, and after that, you'll be free to go.
Judge, have you excused?
Yes, sir. Thanks.
All right, Judge, next is page 16, Johnson, Donald, come on up.
Come on, sir. Are we good, sir?
So where'd you go? Alex? If you can do the, all those.
Usual, no racing.
Usual.
Yes, Judge.
Your last name again, sir?
Johnson.
What was the last name?
Johnson.
Johnson? Thank you. You are Donald Johnson. Mr. Johnson, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 17, 2025, the officer was dispatched to the theft of a motor vehicle at a residence in Harris County, Texas. The officer made contact with the complainant, who advised that his truck was stolen off the property at 12:42 p.m. And the complainant showed officers clear footage of the theft, where the officer observed 3 white males exiting a motor vehicle, one suspect going under the hood of the complainant's vehicle and getting in the passenger seat, and another suspect drive the motor vehicle off the property. The officer got the suspect's motor vehicle's license plates, ran that license plate through Lens, and got an address. When the officer arrived at that address, he observed the motor vehicle used to commit the theft in the driveway and knocked on the door and met with all parties inside the home. All subjects matched the subjects on surveillance, and the defendant had the same clothes as in the footage. The second defendant admitted to driving the motor vehicle and showed where he dumped the vehicle, and the complainant's vehicle was recovered. The first defendant, Mr. Johnson, admitted to helping the second defendant steal the motor vehicle.
So you're telling me that they allegedly stole a car?
Yes, Judge.
He's charged with a misdemeanor theft, Class B.
Yes, Judge.
What is the value of the car?
According to the DIMS, the complainant advised the value was $600.
Does he make a statement that he knows the car stolen?
He makes a statement that he admitted to help steal the vehicle.
Okay. All right, Mr. Johnson, I'm going to find that there's probable cause to go forward with your case. We do have co-defendants in this case, do we not?
Yes, Judge.
I'm ordering you as a condition of your bond not to have any contact with the co-defendants in this case and not to have any contact with the complaining witness in this case. You pick up a new case, you endanger my community, I'm going to revoke your bond, I'm going to put you in jail, and I'm going to make it extremely high. Do you understand, Mr. Johnson?
I do understand.
What do you do for a living, sir? How do you support yourself?
Sir,
How do you support yourself?
I'm trying to get disability right now, sir.
All right, I'll have you fill out an application. Do you mind giving me an application? Do not leave until you sign our bond conditions, otherwise
Yes,
I will
sir.
issue a warrant for your arrest. I'm going to give you an application. I'm going to have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir.
And
Right this way. All right, Judge.
So
next
can you
is
file all those
page
conditions, please?
16.
No contact with co-defendant and complainant, and was there anything else?
Yeah, no law violations and
Yes, Judge.
Right this way.
no weapons.
Yes, Judge.
Plan and sign for the consent. Judge, this.
Where's Mr. Jones?
Here.
James Jones, come up.
Sir.
Oh.
Do you have an arraignment? I'd like to help the lawyers. Vic, can we help the lawyers first so we can get them out?
Oh, I didn't know they were for arraignments.
Yeah. Guys, if you have an arraignment, let me know. Let Victoria know so we can get you out of here.
Yes, sir.
Take your seat for me in the jury box, sir. I'd like to, can we get the case transferred so we can, yeah. And then if you want to go ahead and appoint someone for him as well, Vic, please.
Judge, do you want to go ahead and with counsel?
Yeah. With everyone. Mark,
Page 5.
Yep.
Yeah.
Oh, okay.
Page 5, Savoya, come on up.
Do you have an arraignment today?
Sir?
Do you have an arraignment today?
No,
Okay.
I have, well, I think I have a person who was on the docket because they had a violation on the.
Okay.
I just heard about it. She's from California, so I don't know if she's there. I'll circle back.
You are Ivan Shagoya?
Sir.
Mr. Shagoya, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're also charged with unlawful carrying of a weapon. On the gun case, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 18th, 2025, at approximately 4:30 a.m., the officer observed the vehicle fail to stop at a red light at the East Texas Freeway on Harris County, Texas. The vehicle would have struck the officer's patrol vehicle had the officer not come to a stop. A traffic stop was then initiated and the vehicle continued to drive 0.5 miles before stopping. The officer made contact with the defendant, the driver and sole occupant, and observed an odor of alcoholic beverage, glossy eyes, and slurred speech. Standard field sobriety tests were conducted, HGN 6 out of 6. The officer did not conduct walk and turn and one-leg stand due to safety concerns and the nearby sidewalk not being level. The officer observed a Glock 9mm in plain view from the front passenger window located on the passenger floorboard near the center console, and a PC search was then conducted. A second loaded firearm was found in the center console, and the defendant was then read the DIC and refused. A blood search warrant was signed and executed.
Mr. Shigoi, I'm going to find that there's probable cause to go forward with the case. Have you run his license?
It is eligible, Your Honor.
I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming, I'm going to revoke your bond, put you in jail. No more PR bonds. Do you understand? I'm also ordering you not to be in possession of any weapons as well, sir. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. If he tells me he can't get a hold of you or you've taken off and you pick up a new case, I will revoke your bond. Have you looked to see if he has any prior DWIs, Alex? Please.
He has one moment, Your Honor. No priors.
Okay. All right. So for now, I'll have you sign a reset. Victoria will get you with Felicia for your bond conditions. And after that, you'll be free to go, sir.
Thank you, Judge.
Thanks, guys.
Excuse me.
Please.
All right, the next is page 17. Steve, come on up.
Good morning, Ms. Keys. Ma'am, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On January 18th, 2025, the officer observed the vehicle failing to drive in a single lane on West Grand Parkway in Harris County, Texas. The defendant was swerving in and out of two lanes and came close to crashing into another vehicle in the next lane. A traffic stop was conducted and the officer made contact with the defendant, the driver of the vehicle. The officer observed disorientation, a moderate odor of an alcoholic beverage, and slurred speech. The defendant could not provide ID or insurance, and the officer observed an open container of alcohol on the floorboard next to her feet. The defendant stated she had not consumed alcohol, and the officer observed slow movements and unsteadiness on her feet. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 8 out of 8, one-leg stand 2 out of 4. The defendant was read the DIC and consented to breath. The results were .290 and .294.
So are you telling me that she had alcohol in the car while she's driving?
There was an open container on the floorboards.
Did you put any other indicators like it's cold? Or
No, Your Honor.
Ms. Keys, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand, ma'am? I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail, ma'am. No more PR bonds. Have you run your license, Alex?
I'll run it right now, Your Honor.
Please. And any prior DWIs?
There are no priors, but there is a pending one out of Austin County, it appears.
She has a pending DWI in Austin County?
Yes, Judge.
I'm ordering you as a condition of your bond not to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today promising me that you're not going to drive. If I find that you do, I can have a contempt hearing every single time you drive. It's an offense in and of itself, punishable by up to 6 months in jail and a $500 fine every single time. I am now going to put an ankle monitor on you so I know that you're not consuming, and I'm also giving you a curfew of 7 p.m. to 7 a.m. On your other ankle, you're going to get a GPS monitor. Stop. I don't want you to talk about the case. I can provide you a lawyer today, but if they're telling me that you have an open DWI and now you picked up another one, I have a big problem with that. I was going to provide you a lawyer today, ma'am, if you would like, a court-appointed lawyer. Did you want a court-appointed lawyer? I will provide you a lawyer today. Ms. Keys, if you have a problem with alcohol, I'm giving you the opportunity now to address it on your own. If you do not, I'm going to do it for you, and I promise you're not going to like the way that I do it. Do you understand, ma'am?
Yes.
I'm going to do everything in my power to protect my public at all cost. Every single day, someone dies from a DWI in our county. I need you to fill an application for me, and, or you know what, hold on a second, maybe I Vic, I have an application on file already, so if you just want to appoint her a lawyer, I'm gonna have you sign a receipt with Victoria. You will meet with Felicia for your bond conditions, and after that, we'll have you take your seat while I find you a lawyer. I'm gonna have you sign a reset. After that, you'll get with Felicia for your bond conditions. After that, I'll have you take a seat while I find you a lawyer. Please.
No driving affidavit?
Oh, yeah, no driving affidavit, right.
Marquez, Stewart.
So Alex, on every DWI, I need you to run the NCIC. Yes, Judge. Going on with every single person because yes, Judge. No, it's. Vic, what page?
Page 18, Marquez.
Good morning, Mr. Marquez. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 17th, 2025, the officer was dispatched to an assault. Upon arrival, the officer met with the complainant, who stated she and the defendant have been in a dating relationship for 11 months. The complainant then stated the defendant had been continuously assaulting her, and she showed surveillance video of the incident to the officers. The officers observed the defendant grab the complainant by the hair and strike her several times in the face with a boxing glove. The officer also observed the defendant get on top of the complainant and pin her down, striking her in the face, and the complainant advised she felt pain from all the strikes. The officer observed the complainant to have visible abrasions on her left shoulder and bicep, along with redness on her face.
He just had an assault that was dismissed in October of this past year.
Yes,
Is this the same complainant witness?
complainant.
Okay. Mr. Marquez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with this person whatsoever. I'm issuing what's called a magistrate's order for emergency protection, which is a court order that identifies Ms. Rubio as a protected individual. You're not to commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code. Is this a stalking statute? You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Melbourne Street place. Do you understand?
Yes, sir.
I want you to understand that I'm going to protect every single person in this county by all means necessary. You endanger my public, it's not going to go well for you. Felicia, I want to make sure that he's not consuming alcohol or drugs. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, make your bond very high. Do you understand?
Yep, Judge, the milk was signed last Friday.
Okay. So it looks like a protective order has been issued. I would get to know it because if you violate this protective order, the state can and will file a violation protective order. That is the capital murder of misdemeanors. Do you understand, sir?
Judge, the magistrate also did order a GPS device that was,
Yeah.
installed prior.
I'm okay with that.
I have it on, sir.
Did you want do you need a lawyer, sir? Okay, so you don't want a court-appointed lawyer then? Okay, I'm gonna have you sign a reset. After that, we'll get with Felicia for your bond condition. After that, you're free to go. Don't violate these conditions, Mr. Marquez. It's not gonna go well for you. Do you understand? Okay, come on. Hey, Vic, let's go next. Who's next?
On page 20,
Give me-
Longo.
Given Raymond? Come on. Hey, how are you, Mr. Nunez?
David Montalvo. He's got 2 cases on the docket.
So these are really, really old cases, huh?
You're super old, Judge. She had one attorney, I think it was during the pandemic, that we subbed in on, and then the other case as well, Your Honor. And it was a mix of a lot of things financially and on why he was kind of MIA.
Did you represent him before?
We were on the case, we just never got off. We were on him on the assault case.
Are you wanting to stay on or do you want to get off?
We're gonna stay on, Judge.
Okay.
You just in a way rehired.
So, Mr. Montalongo, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with terroristic threat. Both of those, you're facing up to a year in jail and or a $4,000 fine. I'm going to tell you now, you take off on me again, I'm going to make your bond so high you'll have hair falling out. Do you understand? As it stands now, your case is 1,289 days old on one. The other one is around another 2 years old as well. I'm assuming probable cause has been found already?
I would like to take up probable cause, Your Honor, on the terroristic threat one, if we can.
Okay. Okay, go for it.
Yes, Judge. On February 28, 2023, the officer responded to a terroristic threat, and the complainant stated she is the sister of the defendant, and that prior to the day of the call, the defendant had been sending her threatening messages to her phone. The defendant sent a text saying, "I hope you take a punch to the fucking face. I'm gonna break your fucking face with my fist, bitch. I want to hear your bones break." The complainant stated the defendant has been verbally abusing her and has a history of assaulting their father.
Your Honor, I believe the key element they're missing in this probable cause for the terroristic threat is the imminency. There's nothing showing that this is imminent, it's about to happen, or is going to happen, or some future event.
I mean, I'm going to.
I'm going to, can be very vague, Your Honor. We don't know how long that's going to be. If it's like, hey, I'm coming over right now, or if he said that in person. I think the case law is pretty clear on the imminency on that. For example, like.
You're telling me there's case law that says I'm going to is not sufficient?
I have to look at the specific words of I'm going to, but it references a future event. So if it's in reference to a future event, it's not imminent, therefore it's not, it doesn't meet the requirement.
State response?
So what we have is that they had an argument the previous night, and that the morning of the incident, that's when he sent the text saying, "I'm gonna break your face with my fist." So that would go towards, I doesn't really address the imminent issue, but it does address a future threat.
Montalongo.
Your Honor, I would agree with where you were going, the I'm going to, and just the overall tone of the message is implying imminent and will put a reasonable person in fear.
I think so as well. Mr. Montalongo, I'm going to find that there's probable cause to go forward with your case. I'm now issuing a magistrate's order for emergency protection that identifies the complaining witness in this case as a protected individual. You cannot communicate with this person in any manner. Phone calls, text messages, any way. You're not to threaten, harass, use another person to communicate a threat or harassing behavior. You cannot go within 200 feet of where she lives or where she works. Do you understand? If I find that you violate this court order, I'm just going to put you in jail. Got to understand, I'm going to protect my public at all costs. I don't care who you are, what color, whatever. Do you understand? Now, I'm not waiving his appearance because the cases are super old. We got to figure out where we're going. So I'm going to give you guys one setting to figure out where we're going to go. Is discovery complete on both of these cases?
It appears that the RIP is missing on the terroristic threat, and on the assault, it's complete.
So, okay, so I'm going to give you 30 days. You must be back at that time to figure out what we're going to do. You must either accept a plea bargain from the state, or else I'm going to set your case for trial. You understand? Okay, so if you can please put offers on both of the cases, we'll see you back in 30 days. We'll go from there.
Understood, Judge. Thank you.
That's not.
In the assault, is she the same complaining witness in the assault?
Yes, Judge.
Okay.
Hey, I want to go up also on the assault as well. Yes. Both.
You want it
On both. Yeah, it's the same complaining witness.
And Your Honor, bond conditions would be no contact.
Yeah, no contact.
No weapons. On both.
The
thing is,
two different complainants, Your Honor. One is the father on the assault and the sister on the terroristic offense.
Alex? So I'm granting it in both, so you're not to have any contact with either person. The bond conditions aren't gonna, doesn't really matter because this thing lasts for 61 days, right?
Yes.
So this case ends before the 61 days.
And that is correct. The sister for the terroristic threat and the father for the assault.
Jump in my new car.
All right, Judge, next is page 8. Bear, come on up. Bear.
Fair, you are charged with assault bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 3rd, 2025, the officer was dispatched to a disturbance at a residence in Harris County, Texas. Upon arrival, the officer met with the complainant, who knew the defendant as his sister-in-law. The complainant stated the defendant came to his residence shortly after a verbal dispute with his child's mother, and the defendant arrived and told the defendant told the complainant to come outside and meet with her boyfriend. When the complainant stepped outside, he was assaulted by the defendant by a closed fist to the back of the head. The complainant stated the defendant continued to strike him in the back of the head before he began stumbling down the stairs. The complainant was then assaulted by an unidentified black male while still being assaulted by the defendant and the defendant's sister. The defendant was gone on arrival, but was contacted via a public service by the officer and was ordered to return to the location.
Did the other person get arrested as well?
It appears there is a connected case, Your Honor.
The sister was also arrested.
So we have 3 co-defendants or
No,
2
just
co-defendants?
Yeah, just the sister, Your Honor.
You know of alcohol or any kind of,
There's no allegations, Your Honor.
I see that she's on probation as well. Ms. Fair, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm also ordering you not to be in possession of weapons, not to have contact with the complaining witness in this case, and not to be in contact with any of the co-defendants. Do you understand? Yes? Okay, if I find that you violate these conditions, I'm going to revoke your bond. I'm going to put you in jail. I'm going to protect my community at all costs. Do you understand, ma'am? Do you need a lawyer, ma'am? Okay, Ms. Fair, I need you to fill out an application for me. I'll provide you a lawyer after that. Don't violate these conditions. Do you understand, ma'am? Okay, please. We'll have you sign a reset. You'll get with Fleischer for your bond conditions, and then we'll have you fill out an application.
I spoke with the complainant and he's.
Ma'am, hold on. Come back up.
He's no longer living, he still has the lease to the residence of the 1180 Grant Road, but he's not living there anymore because the co-defendant lives there. He's actually living at his sister's residence, so if we could get a restriction, like a.
Sure, just provide it to Felicia so she knows, and then we'll put that in the order as well that she's not to go to this location.
Yeah, Judge.
Okay, okay, ma'am, please.
The financial affidavit?
Yes, ma'am. Yeah. You were Dedrick Addison?
No, Judge, they didn't come up. Page 6, bottom of 6.
Mr. Cogdill? Yes, sir. Sir, you're charged with terroristic threat of a family or household member. That allegation kicks it up to a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On March 1st, 2024, the officer is dispatched to a terroristic threat call in Harris County, Texas, and the complainant and the defendant have an on and off dating relationship. The defendant is also the father of the complainant's child. The complainant stated they got into a verbal argument and she recorded it. The officer listened to the recording and the defendant stated he was going to beat her mom up and kick the door open and kill everyone in the house. The defendant also stated he has nothing to live for.
Mr. Cogdill, I'm going to find that there's probable cause to go forward with your case. Do we know if she wants to have contact with him or not?
Let me see if a RIP has been. Your Honor, there's been no contact made as of now.
Until I know that this person wants to have contact with you, I'm ordering you not to have contact with this person and not to be in possession of weapons. Do you understand? Just be good. It's not hard, you know. Would you like me to provide you a lawyer today? Okay. Would you mind filing no contact, no weapons? Yes. I'm gonna give you a lawyer today. Just don't pick up any new cases. Be nice. That's all we're asking you to do, you know? Really. I'm gonna have you sign a reset, Victoria. Let's see. I have an application on file already, so what I'll have you do is I'll just have you take a seat in the jury box. Wait to get your lawyer. I need you to sign these bond conditions as well, and then we'll go from there, all right? Please, sir.
Right this way. All right, Judge, next is page 18, Martinez. All right, Judge, next counsel is here on page 28.
Mr. Downey. Hi. Wow, 2 times in 1 week, huh?
Back to back.
Go play the lottery. It's Schreiber?
Yes, sir. Judge, Kyle Schreiber.
Come on up, Mr. Schreiber. Good morning, sir. Sir, you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 16, 2025, the officers made contact with the complainant at a residence in Harris County, Texas, who stated the defendant came to the cul-de-sac on a dirt bike, began revving the engine, which got the complainant's attention, and the complainants began recording the incident on their cell phone. The officers reviewed a video from the cell phone showing the defendant sitting on a dirt bike, continuously revving the engines, and the complainants made contact with the defendant, and the verbal argument began. The defendant made the comment, "It's y'all asses. I know where you live. I got y'all." And the complainants feared for their lives, believing the defendant would return to cause them bodily injury. The defendant's residence is only 0.7 miles from the complainant's residence.
Judge, I think the facts are going to show this stems from a confrontation that the neighbors had with his children, and that there's more context to the alleged threat that explains that. However, my understanding is.
So are they next door neighbors?
No, they live in the same general neighborhood, but there's already a pretrial bond condition of no contact.
Got it.
And I've explained to Mr. Schreiber that staying away from them is good.
Really, that's all we're asking you to do. You know, you've got a great lawyer. Listen to him. He'll take care of you. I am going to find that there's probable cause to go forward with the case. Just don't have any weapons, don't have any contact, and all will be well. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Downey. He'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you've taken off, I'm going to issue a warrant for your arrest. Just don't pick up any new cases, okay? We'll have you sign a reset with Victoria. We'll have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. All right? Judge, thanks, guys. Please. Can you file the no contact?
Yes, Judge.
Given a ring?
Yes, it's for Blake Jenkins.
Okay.
And Judge, I showed up and he is wanting me off the case. He wants a new attorney.
Jenkins, come up, please. You have Gibson, huh, Sean? We'll do that next.
I think I've got Jackson. Yeah, Jackson.
Hey, no talking. Speaking of, why don't we get some out and start signing conditions when we get them out?
We're waiting on bond conditions.
All right, let's get them out.
Judge, this is Jenkins on page 14 and 15.
I'm signing conditions so we can get some people out of here, please.
You signed those remote upstairs.
I did. Okay, so why are we here on Mr. Jenkins? What happened?
Yes, there was, he was on bond and there's a new offense, so we're here for an arraignment. And then,
So he's on bond for 2 cases. He's now picked up a 3rd case. Is this right?
that's correct, yes.
Mr. Jenkins, you now stand charged with the offense of reckless driving. You are facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, Judge. On January 12, 2025, at 6:26 p.m., the officer observed the defendant's vehicle traveling at a high rate of speed on a feeder road without headlights on. The officer checked the speedometer and it read 80 miles per hour while the defendant's vehicle was traveling faster. This occurred in a 50-mile-per-hour zone. The officer observed the defendant's vehicle make an unsafe lane change, cutting off a motor vehicle and reaching a speed of 106 miles per hour with moderate to heavy traffic. The officer observed another unsafe lane change while attempting to catch up to the defendant's vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle.
Mr. Jenkins, I'm going to find that there's probable cause to go forward with the case. Does he have a valid Texas driver's
Yes, eligible.
I'm now revoking your bond on the other 2 cases. You will go into custody with me because you picked up a 3rd case, sir. Goes with you.
Judge, he also is wanting me off the case. So I didn't know if we wanted to address that.
I'm not going to talk to you about this case. You have a lawyer. You need to talk to the lawyer.
Talk about my two cases before that, sir.
I'm not going to talk to you about this. We'll put you in back if you want. I can give you a new lawyer today. I'll give you a lawyer, another. If you want to get off, and I'll provide you another lawyer. It's the 3rd case. Unacceptable. So we'll take you off and we can appoint another lawyer on all 3.
Lyra?
Yeah,
James.
Right, Judge Reagan?
No. Give me a second. So, 5,003 on the old cases, please. I need to get Mr. Darvish here real quick on Gibson.
It's Jackson.
Violations, page 13 and 14.
Gibson, come up.
Your Honor.
Sean, what? Tell me.
I have Mr. Jackson.
Oh, I'm sorry. I was looking at
JP has Gibson.
case. Sorry about that.
Jack,
No worries.
come on up. Page 13 and 14, Judge.
Mr. Jackson, you now stand charged with another case. You were charged with possession of marijuana. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 18, 2025, the officer observed the defendant's vehicle traveling 78 miles per hour in a 60-mile-per-hour zone, have an expired registration, and failed to maintain financial responsibility on Interstate 45. The officer noticed a prominent odor of marijuana trailing the defendant's vehicle, and a traffic stop was initiated. The officer observed the defendant to be in the driver's seat with a black bag and a female to be in the front passenger seat. The defendant rolled down the passenger window, and the officer observed a cloud of smoke emitting from the vehicle with an odor of marijuana. The defendant was asked to step out of the vehicle with the black bag. The black bag was opened, and the officer observed a clear jar with a green leafy substance known to be marijuana based on training experience, along with a digital scale and individual baggies. The defendant was searched for weapons, and the officer found more packages of marijuana inside his private area. The weight of the marijuana was 1.82 ounces.
And Your Honor, if I could adjust probable cause.
Okay.
Your Honor, so while I don't dispute the reason for the stop here, I think there's a couple things that stand out. So there is a alleged smell of marijuana that comes from the vehicle, and then an alleged cloud of smoke that comes from the vehicle as the windows are open. So first off, the officer doesn't specify whether this is a cloud of course, burnt marijuana, which I would assume, or vaped marijuana, because those are 2 very different things with 2 very different distinct smells. Additionally, if the officer is pulling them out and looking for marijuana and he has this cloud, then he would be looking for burnt marijuana, right? So he would be looking for a roach. He would be looking for a blunt. What he does is he looks inside of a plastic bag. If we have embered marijuana or we have a lit blunt, it's certainly not going to be in a plastic bag without the smell of burning plastic. Additionally, the marijuana that is found in the bag is in a sealed glass jar container, something that would not emanate a smell because a glass jar is essentially smell proof. In this instance, I think we have an officer who went too far with the search because we have Mr. Jackson here who did not admit to possessing marijuana, did not admit to this being marijuana. The statute, of course, requires that this has to be marijuana, and we know we have the issues, of course, with the hemp bill. But Your Honor, if you're not aware, you can go into any head shop, purchase flowered hemp, open it, and it smells, looks, everything about it is identical.
I understand,
to
and that,
marijuana.
yes, I agree with you for a beyond a reasonable doubt standard, but here, this is just mere probable cause, right? There's a good stop, goes to the car, smells marijuana, there's a plume of smoke that comes out. Not only that, Sean, he signed an affidavit that he wasn't going to drive. He's not supposed to be driving regardless.
And I get the driving aspect of it, but I don't see how a cloud of marijuana from burnt marijuana gets you inside of a plastic bag. At that point, it becomes a fishing expedition as opposed to looking for the actual contraband, which he suspects that would be in the vehicle.
I don't know. I mean, I think that there's certainly enough to go forward. Beyond a reasonable doubt, I don't know. But this is just a probable cause standard, which is the low stand, you know? So
I understand.
I'm gonna find that there's probable cause to go forward with your case, Mr. Jackson. I ordered you not to drive. He's a driver in this car?
Yes, Judge.
Okay. I'm now revoking your bond. Goes with you. Sorry, Sean, but you know, he promised us he's not gonna drive. He signed an affidavit. He knows. He knew.
And Your Honor, will a new bond be set? And if so, can we get that amount set?
So I'll leave the first bond as is. The first case, I'm gonna do it at 5,001.
Okay. So first case, 5,001, and then the new case, of course,
I'll
would be
leave the
bonded out
first
as.
one, or the second one as is, though.
Which case number?
So the one that's on page
14 or 13?
14, that one gets revoked to 5,001. Yeah.
Okay. Okay. Thank you, Your Honor.
Okay, thanks,
I believe
Sean.
That's all.
You don't have anything else with us today?
Nope, I'm in Fort Bend for the rest of the day.
All right, good luck, my friend.
Thank you, Your Honor. May I be excused? You too.
All right, bye.
Bye.
Page one.
Aris Delci? Ma'am, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to.
On January 16th, 2025, at approximately 10:25 p.m., the officer was traveling on East Sam Houston Tollway and observed the vehicle traveling at a high rate of speed, overtaking other motorists and changing lanes without signaling. The officer observed the vehicle get on Ship Channel Toll Bridge and pace the vehicle at 75 miles per hour in a 50 mile per hour zone. The vehicle further failed to drive in a single lane and a traffic stop was initiated. The officer made contact with the defendant, the driver of the vehicle, and observed the defendant to have slurred speech and odor of an alcoholic beverage. Standard fields of righted tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The defendant was read the DIC and refused to provide a specimen, and a blood search warrant was signed and executed.
Ma'am, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming anything of this nature, I'm going to revoke your bond and put you in jail. Do you understand, ma'am?
There's no driver's license on file for the defendant.
Okay. Any prior DWIs?
No priors, Your Honor.
Okay. If you do not have a Texas driver license and liability insurance, you are not allowed to drive. Do you understand? You will be signing an affidavit with me today promising me you're not going to drive. I take it extremely serious. You just saw what happened. If you don't have a license and insurance, do not drive. Would you like to apply for a court-appointed lawyer, ma'am? Okay. What's going to happen now is I will have you swear to it that you're not going to drive without those two documents. I will have you sign a receipt with Victoria. We will have you get with Felicia at some point for your bond conditions. In the meantime, we'll have you fill out an application, then I'll have you speak to a lawyer here momentarily. All right? Please. And then if you could give her an application. Do you mind, please?
12, Humphrey, come on up.
Yeah, this was just a bit. Yes. These are some from the viewer operates already.
Good morning, Mr. Humphrey. So you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you're not affordable, one will be appointed to you.
Yes, Judge. The officer was conducting a follow-up investigation and spoke to the complainant. The complainant knew the defendant by name and sight as they were in a dating relationship for 2 years. The complainant stated they ended the relationship in 2023, but continued to be friends because they worked in the same building. The complainant stated she initiated contact with the defendant via cell phone. The defendant showed up at her location and talked. The defendant asked to hang out, but the complainant stated she was busy. The complainant left the location and got a call from the defendant, and the complainant told the defendant to leave her alone and hung up. The defendant called her 35 times and called her using a secondary number. The complainant blocked both numbers, and the complainant got approximately 100 calls from a no-caller ID number. The complainant answered, and the defendant told the complainant to unblock her, and the complainant hung up. The complainant arrived at her office and saw the defendant calling her and was knocking and attempted to open the door to her suite. The complainant was escorted to her vehicle, and the defendant contacted the complainant 39 times via his cell phone, 1 time via a secondary number, 6 times via email, and 100+ times from a no-caller ID. The defendant spoke to the officer and admitted to calling the complainant 100+ times from his primary phone number and his secondary number and sending emails because she blocked him.
Mr. Humphrey, I'm going to find that there's probable cause to go forward with your case. You're on bond for murder. You now picked up a harassment case. You're lucky to be out on bond. Now you picked up a new case. I mean, really. I'm ordering you as a condition of your bond not to have any contact with the complaining witness. I'm going to put a GPS monitor so I know you're not going anywhere near this person. I will protect my community at all costs. Do you understand, sir? You're not to consume alcohol, illegal drugs. I don't want you going within 1,000 feet of where she lives, where she works, no weapons. You know, life is really short. It would really suck to spend the next 50 years in a 6x9 box. There's so many fish in the sea. It's not worth it. You know what I mean? Really. Move on. Just life's way too short. Really. Do you have the ability to hire a lawyer, Mr. Humphrey? Or do you need a court-appointed lawyer? Okay. Just, I want my community safe, man. That's all I want. Please, you know, please. I have an application on file already. So I'm going to have you sign a release of Victoria. I'm going to have you meet with police for your bond conditions. I'll provide you a lawyer here momentarily. Just think before you act. Come on.
Judge, would you like me to mirror the felony reports?
No. I just no weapons, no drugs, no alcohol, and no contact with this person. They're going within 1,000 feet of where she lives or works, please. So I've got Mr. Cedillo here on an arraignment with Gibson over there. We can do that next. You are Jesus Montes. Mr. Montes, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer met with the complainant who stated that her and the defendant are married, and while at the defendant's sister's home, they got into an altercation. The complainant stated that the defendant grabbed her by the neck and pulled her hair, causing pain. The officer observed redness to the complainant's neck area.
Mr. Montes, I'm gonna find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. There is a protective order that has been issued in this case. I would get to know it. If you violate the protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. You understand? Do you have the ability to hire a lawyer, sir? Okay. We'll provide you a lawyer today, but don't pick up any new cases. Don't endanger my public. You understand? I'm gonna have you sign a receipt, Victoria. We'll have you take a seat in the jury box while we get your conditions. We'll have you sign it, and then we'll provide your lawyer here momentarily.
Good. No financial affidavit, Judge?
No, there's one on file already.
Okay, we'll just jump from Don Howard.
Gibson.
Gibson, okay. Gibson.
JP, you ready?
Did he file an attorney of record, Judge? I don't have one. Montez, go ahead and sign for yourself.
Mr. Cedillo.
I'm here, Judge.
I've got Mr. Gibson in front of me. So what are we doing? This is an old case, huh? Was this a 2B? Alex, is this a 2B?
It was, Judge.
Yes, Judge, it was a 2B.
Mr. Gibson, you were charged with criminal mischief. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Your lawyer is here with you on Zoom so that you know you're not alone.
Yes, Judge. On June 24th, 2020.
Hold on.
Yes, Judge. Yes, Judge. On June 24th, 2024, the officers were dispatched to a burglary at a warehouse in Harris County, Texas. The defendant and another unknown male were seen on a security camera approaching the warehouse in an SUV and gaining entry to the side of the building by pulling back 2 metal sheets that lead to 2 large holes on the wall. The complainant estimated the damages to be valued at approximately $800, and the complainant stated the defendant broke into the property to attempt to retrieve items that belonged to him. The complainant stated to have filed a civil lawsuit against the defendant for not paying rent.
Say it again?
The complainant filed a civil lawsuit against the defendant for not paying rent, and that the complainant was there to obtain property for the defendant.
Mr. Gibson, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Don't go back to this location. Do you understand? If you pick up a new case, if you go back to this location, I'm going to revoke your bond and put you in jail. No more PR bonds. Okay. Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Cedillo. JP, have you filed an attorney of record?
No, Judge, it's brand new. I'll get that done today, Your Honor.
Please.
Judge, I know you found PC, but just can you indulge me and can I just hear how how my client was identified? I did not hear that.
Surveillance video.
Yes, Judge.
Okay.
That's what they say.
I mean, is there any description that it was him, or did anyone say that it looked like my client or anything like that? Did the officer look at the surveillance footage?
Yes, the DIM states explicitly that the defendant is seen on security camera coming onto the property.
Okay, we'll take a
I
look
mean,
at it.
if you get the video, it shows something different, come back. I'm always ready to entertain anything at a later time, you know?
Of course, Judge.
So,
thank you.
But until that time, don't pick up a new case. Don't go back. All right, so Vic, you want to give me a date?
Yes, Judge, how is March 25 through the 27th?
Let me see, Judge.
Judge, was that state's bond conditions?
Yeah.
Okay.
Judge, March 25 will work?
Yes.
Okay, jurors. Okay, so for now, I'll have you sign a reset. We'll have you take a seat while we get your bond condition. We'll have you sign it, and then you'll be free to go. Okay?
Thank you, Your Honor.
Thanks, JP.
On page 4, call for, come on up.
Sir, hi, Mr. Cole. Do you mind filing those conditions?
Yes, Judge, no contact, no returning until, Judge.
Can you sign documents for Cocktail and Schreiber, Judge?
Oh.
Go ahead and sign, please. Go ahead and save her behind you.
Okay. Signed. You are Jonathan Caldwell. Mr. Caldwell, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle traveling 35 miles per hour in a 20-mile-per-hour zone on Pine Dust Lane. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the defendant was not wearing a seatbelt. The officer further observed an odor of marijuana and asked where the marijuana was located. The defendant stated the marijuana was located in the back seat. The defendant gave consent to search the vehicle, and the officer found a clear plastic sandwich bag with a green leafy substance in the back seat and a glass container with a green leafy substance. The total weight was 0.921 ounces.
Okay, Mr. Caldwell, I'm going to find that there's probable cause to go forward with your case. Have you looked to see if he has a license?
It's not eligible, Your Honor.
Okay, you're not allowed to drive. If you don't have a license, do not drive. Do you understand? If you go get a license, if you get insurance, come back to me. I'll take this restriction off. That's your only condition. Don't get in trouble and don't drive. You understand? I'm going to have you sign an affidavit, which is a promise you're making to me. That's the only condition, Mr. Caldwell. Don't drive. Now, you have a lawyer. Remain in contact with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get in contact with you, I will revoke your bond. Just don't pick him a new case and be good. All right? Come on. Thanks, Mr. Cole. You too.
Judge, are there gonna be states on?
No, I'm not putting any conditions, just the no driving affidavit.
Council is approaching on page 2. Barnes.
Mr. Pruitt.
Hello, Judge.
Happy Friday, man.
The one you, on Barnes, he was in jail in Fort Bend County.
Oh, we reinstated, okay.
Here today because you wanted bond conditions.
Good morning, Mr. Barnes.
Good morning. Sir Davis, sir.
You made it out.
Yes, I did.
Just, we're not asking for much, man. Just be careful, behave, don't do anything you shouldn't do, you know? Is those cases are still open in Fort Bend or what?
The case is still open in Fort Bend. It's still pending. Your next court date is down there.
It's on March. Not all the cases are open.
One of them still open. Paul Two's representing him. I talked to Paul yesterday, and it's set for sometime in March. I can't recall the exact
It's okay.
date.
Have we done PC on this yet or no?
We haven't done anything because he was in custody.
Right. Okay, so we're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I just want to see if there's enough to go forward on your case. I don't know what happened. Okay, Alex, please.
Yes, Judge. On September 4th, 2024, the officer observed a hand-to-hand transaction between the driver of a parked vehicle and another individual. The defendant was a passenger in the vehicle, and the officer approached and smelled a strong odor of marijuana. The officer asked the defendant to step out of the vehicle and saw in plain view a scale in the driver's side door, and the officer detained the defendant and the driver. The officer found a bag of marijuana in the defendant's waistband pursuant to a pat-down, and the weight of the marijuana was 1.27 ounces.
Telling me he saw him do a hand-to-hand transaction or someone else?
The driver of the vehicle was a hand-to-hand transaction, and when he approached the vehicle, he asked the defendant and the driver who did the hand-to-hand transaction to exit. And furthermore, the officer smelled an odor of marijuana.
I know, but why would he search him?
What?
I get it on the driver because he sees the hand-to-hand contact with them, but he's just sitting there.
The only thing would be officer safety, just the pat down. That.
No. All right, Mr. Barnes, I'm going to find no probable cause. Just be careful. All right? Really. You hang with dogs, what happens? No. Well, you get fleet. Well, you can get bit too, right? Please.
It's a bad dog.
Just don't hang out with the wrong people. All right?
Yes, sir.
Come on.
Christopher.
Thank you, Your Honor.
AKA is going to clarify.
Wait, are we doing page 23 or which one?
23,
Oh, and 30?
22 and 23, it says on page 30 is another case, AKA Williams.
With her?
Yes. Yes. Kyle Schreiber.
Yes. Yes, his last name is just look. From our emails, you put that have been.
No,
We really have 4 open cases now with Miss Newton? What is your true name, ma'am? Miss Newton, you now stand charged with 2 more cases. You're charged with another theft case. You're also charged with failure to identify oneself to a peace officer. You are facing up to 6 months in jail and or a $2,000 fine on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On January 17th, 2025, the officer was dispatched to JCPenney's regarding a theft or shoplifting. The officer made contact with the complainant, a loss prevention employee, who stated the defendant, Newton, and a co-defendant, Woods, entered the store, selected several items, put the items inside a personal bag, and exited the store, passing all points of sale without paying for the concealed items. The complainant stopped the defendants outside and escorted them back to the loss prevention office. While at the office, the defendant identified herself as Christiana Ray to the officer. An AFIS search came back to reveal the defendant's real name with an outstanding warrant out of Harris County, Texas. The total value for the items is $268.
She has a theft from December of 22, a theft from June of last year, and now 2 more cases. Was she on bond for either of these cases when she picked up the 2 new cases?
Let me see, Your Honor.
I'm looking at Miss Newton here. Was she on bond for any of these cases? Or were they all just in open status? It's 254. 8009.
Or it appears bond was made after the new cases. On the 19th, the new cases were picked up on the 17th.
In the court processing page, last name KOTUN, that's the original case, and there were multiple bonds posted on that one. A GOP and a surety, and then these other cases got put in. So it's a 3rd name.
On the 251, it appears she posted bond only one time on the 19th of this month. On the...
Yes, Judge, on the 243.
That's the one that was in
GOP
status, right?
Yes, Judge.
Where are all those from?
So the theft, cause number 243 was a Dick's Sporting Good.
Dick's,
and then 251 theft was a Sephora, and then the most recent theft was a JCPenney.
Miss Newton, Miss Williams, I'm going to find that there's probable cause to go forward with the case. I'm now putting a monitor on your ankle so I know where you are at all times, and you are forbidden from going to JCPenney, any JCPenney. You're forbidden from going to any Sephora. You're forbidden from going to any Dick's Sporting Goods. If you pick up a 5th case, I tell you now, your bond is going to skyrocket. Do you understand, ma'am? Would you like to apply for a court-appointed lawyer, ma'am? going to have you sign a reset with Victoria. After that, you'll get with Felicia for your bond conditions. Do not pick up a fifth case. I'm telling you now. I don't know what you're doing, but you pick up another case. You're also not to hang out with the other person, the co-defendant in this case as well. Do you understand? So can you reach out to the MAC for her and then she'll have conditions with Felicia? Okay, please, ma'am. Morning, Mr. Price. Sir, you're charged with two cases. You're charged with assault of a family member. You're also charged with a garden variety assault. On both of those, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The complainant, Terrell, and the defendant were in a previous dating relationship. The defendant followed complainant Terrell into a bathroom of a bar and began to slap complainant Terrell multiple times in the face, struck complainant Terrell with a closed fist multiple times in the face, and grabbed complainant Terrell by the throat, but did not impede breath. The defendant would not allow the complainant to leave. The complainant Asher, friends with complainant Terrell, walked into the bathroom. The defendant struck complainant Asher in the face with a closed fist.
Who?
So complainant Terrell is the AFM and complainant Asher is the ABI.
Terrell, is that a...
That is a dating relationship.
Got it. Okay. Mr. Price, I'm going to find that there's probable cause to go forward on both of your cases, and I'm ordering you not to have contact with either person. Do you understand? On the family member case, I'm not seeing a protective order issued on Price. Can you see one, please?
I don't see one file
Okay. I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Terrell as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat of harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Pierwood Drive house. Do you understand? If you violate this court order, the state can and will file a violation protective order against you. It's one of the worst cases you can pick up. So you're also not to have contact with the complaining witness in the assault case and not to be in possession of weapons as well. We're going to file these conditions. You'll need to sign it. Did you need a court-appointed lawyer today, Mr. Price? Okay. You can reach out to the MAC. I've got an application on file. I'm going to have you sign a reset, Victoria. We'll have you take a seat in the jury box while we get all your bond conditions. You'll sign it, and then we'll provide your lawyer here momentarily, sir. You were Jamarcus Randolph. Mr. Randolph, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine on that one. You're also charged with possession of marijuana. On that one, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle bearing a temporary buyer's tag with an expiration date of December 25th, 2024. The officer ran the expired buyer's tag through NCIC and observed the license plate to not be registered to any vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the front seat passenger. The defendant admitted to having printed the buyer's tag himself and putting it on the back of the motor vehicle. The defendant stated he printed the buyer's tag at UPS or something. The officer observed a strong odor of marijuana, and the defendant admitted to smoking earlier that day. A PC search of the defendant's person and vehicle were conducted. The officer located a small plastic bag containing a green leafy substance known to be marijuana based on training experience in the defendant's front right pocket, and a clear plastic bag containing marijuana in the center console of the vehicle. The weight was 0.3 ounces.
All right. Mr. Randolph, I'm going to find that there's probable cause to go forward on both of your cases. Can you look up to see if he has a...
It's not eligible, Your Honor.
You're not allowed to drive. I don't care what's going on in your life, Mr. Randolph. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, it's not going to go well for you. Do you understand? If you want to drive, go get a license, get liability insurance. If you can show to me that you have both of those things, I'll take this restriction off. But I'm going to tell you now, if I find that you do, it's really not going to go well for you, sir. Did you need a lawyer today, sir? Okay. Okay. See, show file. I need you to fill out an application for me. I can provide you a lawyer today. Above all else, in the short life that we have, do not drive. This is an affidavit that you're going to be promising me you're not going to drive. Do you understand? All right, come on.
Then we're not done with the railings yet.
That's the only condition.
All right, Judge, next is page 26, Richard. Get the sign.
Did you say,
Richard, page 26.
good morning, sir. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. So this is the one that we were talking about the other day, right? Where it looks like initially a magistrate found no PC, right? But then we have a refile the next day. Will you go ahead and read PC? You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The officer met with a complainant who stated that the defendant is her ex-husband, and the complainant advised that on August 25th, 2024, the defendant was at her residence regarding a visitation. As the two children went into the home, the complainant told the defendant to leave. The defendant then pushed his way into the home and pushed the complainant against a wall, causing pain. The officer observed surveillance footage showing the defendant push and strike the complainant in the upper chest area.
Oh, there's a strike.
Yes, Judge.
Okay, Mr. Reichert, I'm going to find that there's probable cause to go forward with your case. A protective order has been issued in this case. Get to know it. If you violate the protective order, the state can and probably will file a violation protective order against you. It's one of the worst cases you can pick up. You're not to have contact with this person and not to go where she lives or where she works. Do you understand? No, I can give you a lawyer.
Sir?
I can give you a lawyer if you'd like.
Yes, sir.
Talk to the lawyer, and the lawyer can come up and talk to me. I just don't want you to say anything. Believe it or not, I'm trying to help you because I've got a bunch of DAs here. Whatever you say, they're going to try to use it against you. All right? Do you need a lawyer?
Yes, sir.
All right. I'm going to have you sign a receipt of Victoria. We'll have you in the jury box. If you can file the conditions, no contact, no weapons, please.
Yes, Judge.
Have you signed the conditions, and then we'll provide your lawyer here momentarily. Okay? Please, sir.
You need this, Judge?
No, I have it on file. Thanks. Morning, Ms. Rocio.
How you doing?
Ma'am, you're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Hold on. We have a co-defendant here.
I knew, but I don't know if it's the one we already have on docket.
Do you have a cause number on the co-defendant?
Yes, Judge, 1 moment, it's loading. Okay, whenever you're ready. The cause number for Smoots is 2523672.
Okay, yes, Judge, he's on the jail docket.
So we have it?
Yes, I think he's on for the 27th.
So he's still in custody?
Yes, Judge, he has felony today, so we're getting him Monday.
Oof. All right, Ms. Rocio, we're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
Yes, Judge. On August 9th, 2024, the officer observed a silver Nissan with an expired registration and a traffic stop was initiated. The officer observed a strong odor of marijuana from the vehicle and observed marijuana in the back seat in plain view. A PC search was conducted and the driver, Mr. Smoots, was detained. The female passenger began to act very irate and yelled at the officer. The officers told her to back up and stop interfering multiple times, and she refused multiple commands. The officer attempted to place her into handcuffs, and she began to walk away and pull away from officers. The officer had to assist her to the ground, and she was identified with her driver's license.
Ms. Rocio, I'm going to find that there's probable cause to go forward with your case. The only condition I'm placing on you is not to have contact with the co-defendant in this case. You understand? Sorry? Do you have a lawyer? Do you want a lawyer? Okay, we can provide you one today, but talk to the lawyer. The lawyer can answer any questions that you have. I don't want to answer anything now because whatever you say, they can use it against you. Just the only thing I'm asking you to do is don't pick up any new cases. Don't have contact with the co-defendant in this case. Mr. Smoots, do you understand? All right, can you file those conditions for me, please? We'll have you sign a receipt, Victoria, and then we'll have you take your seat in the jury box. We'll get all the documents ready for you. You're in line. It's Arraignment Friday. Mhm. All Fridays are like this. You were Kiana Ware. Miss Ware, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 19th, 2025, the officer was dispatched to a two-motor vehicle accident on the 1900 block of Southwest Freeway. The officer observed the defendant's vehicle with damage to the front right side, and the officer made contact with the defendant, who was observed to have a strong odor of an alcoholic beverage, slurred speech, bloodshot, glossy eyes, and poor balance. The defendant stated she was coming from a friend's house, was driving home, and had drank 7 glasses of wine. The officer observed the defendant to be emotional and have changes in mood, and a witness, the other vehicle involved in the collision, observed the defendant in the driver's seat. Standard field sobriety tests were administered, HGN 6 out of 6, walk and turn 6 out of 8, one leg stand 4 out of 4. The defendant was read the DIC and refused to provide breath. A blood search warrant was signed and executed.
Are DWIs? Can you
No,
run?
Your Honor. And
Your
eligible
NCIC?
driver's license.
Have you run her NCIC?
Yes, Judge, and there's no prior DWIs.
All right, ma'am, I'm going to find that there's enough probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming, I'm going to revoke your bond, put you in jail. You understand, ma'am? Okay. Did you need a lawyer today, ma'am? Okay, we will provide one to you. I need you to fill out an application for me, and then I'll have you speak to someone. Don't use. That's all I'm asking you to do. Don't pick up any new cases. Don't be a danger to my public. Do you understand, ma'am? Okay, come on.
This way, go ahead and sign for your Lisa. Judge, there was no driving restriction there?
No, she has a license, so she's okay. Just no alcohol, no tip. Miss Williams, ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. Okay. On January 13th, 2025, the officer was dispatched to a disturbance regarding a female in a motor vehicle on Westheimer Road. The officer observed the defendant stopped in the parking lot of a gas station and the officer observed the defendant exit the vehicle from the driver's side while holding her keys. The first and second complainant had previously seen the defendant driving between 2 gas pumps, hitting a trash can before stopping in the parking lot. The defendant proceeded to walk towards the officers, who observed the defendant swaying side to side, observed bloodshot glassy eyes, observed poor balance, and a strong odor of an alcoholic beverage. The officers then detained the defendant and performed standard field sobriety test, HGN 4 out of 6, walk and turn 7 out of 8, and one leg stand 3 out of 4. The defendant was read the DIC and agreed to provide a specimen of blood.
Okay, any priority to be iced?
No, Your Honor.
And I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. Do you understand, ma'am? Did you say she has a valid Texas driver license?
I'm here right now, Your Honor. It's eligible, Your Honor.
Okay, you can drive as long as you have a license and liability insurance. If you don't, do not drive. Do you understand? Do you need help with a lawyer today, ma'am? Do you want one? You need one. Okay, I'll provide your lawyer today, but so for now, I'll have you sign a receipt, Victoria. You will have to meet with Felicia of your bond conditions. For now, we'll have you take a seat in the jury box while we find your lawyer, okay? Please.
Right this way.
Mr. Lestrep, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On September 16, 2024, officers were dispatched to a Walgreens in Harris County, Texas. The officers spoke.
Same Walgreens as always?
Yes, Judge, it is. And the officer spoke with the complainant, the store manager, who stated she knows the defendant by sight and name. The complainant was able to identify the defendant and stated the defendant is a habitual shoplifter at the location. The defendant has a trespass warning from January 24th, 2024. And on the 17th of January in 2024, the defendant stole a total of $145.81 in merchandise. On the 24th of January, the defendant stole $100.71 worth of merchandise. And on July 17th, 2024, the defendant stole $105.80 worth of merchandise. On August 1st, 2024, the defendant stole $43 worth of merchandise. And on August 15th, the defendant stole $70 worth of beer. On September 16th, the defendant stole $70.49 worth of merchandise. On November 30th, 2024, the officers stole $30.25 worth of beer. The total value for all thefts was $506.86.
Let's go out of jail.
Mr. Lestrep, I'm going to find that there's probable cause to go forward with the case. I'm ordering you not to go back to this Walgreens. I'm putting an ankle monitor on you right now. If I find that you violate this, you go within 1,000 feet of this store, I'm going to revoke your bond. I'm going to put you in jail. No more PR bonds. Do you understand, sir? 1,000 feet, you're not to go within this Walgreens. Do you understand?
Yeah.
I will provide you a lawyer today, Mr. Lestrap, but I'm done. This is it. Do you mind reaching out to the mag for Mr. Lestrap, please? Okay, I'm going to have you sign a reset. You'll get with police chief your bond conditions, and then I'll have you talk to lawyer here momentarily, Mr. Lestrap.
Judge, what are the other conditions other than the refrain?
That's it. Just don't go over there. He gets it on today.
Yes, what did she?
Amir Hayes, come up. How many more do we have? How many more?
This is the last one, Judge.
Wonderful.
Good morning.
Mr. Hayes, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Actually, you're charged with 2 counts of assault. You're facing up to a year in jail and or a $4,000 fine. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On June 3rd, 2024, the officers were dispatched to an aggravated assault call, and the officers met with 2 complainants. The first complainant was in a prior dating relationship with the defendant. The second complainant is the first complainant's mother. The first complainant stated the defendant and her were at a party when the defendant started to become upset, and the first complainant was not responding to his advances. The 2 got into a verbal altercation, and during the verbal argument, the defendant punched the first complainant in the face several times, causing pain. The second complainant stated she observed that the defendant and the first complainant were in a verbal argument and went over to intervene, but was struck in the face with a closed fist by the defendant, causing pain. The defendant then left and returned with more family members, and the first complainant stated the defendant continued to assault her until gunshots were heard and the defendant fled.
Hey, stop.
I'm sorry.
Do we know if alcohol played a part in any of this?
There are no allegations of alcohol, Your Honor.
Mr. Hayes, I'm going to find that there's probable cause to go forward on both of your cases. In both of your cases, protective orders have been issued. I would get to know them. If you violate the protective order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up. Do you understand? I am ordering you not to have any contact with either of these people at all throughout the duration of this case and not to be in possession of weapons. I'm going to do everything in my power to protect my public at all costs. Be aware of that. If I find that you pick up a new case, you endanger my public, I will revoke the bond, put you in jail, and I'm going to make them extremely high. You have a lawyer. I don't know where your lawyer is, but because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with the lawyer. If the lawyer tells me he can't get hold of you because you're playing games, you're not responding to phone calls, text messages, I will issue a warrant for your arrest.
Okay.
For now, I'll have you sign a reset. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then we'll just wait for your lawyer to get here, sir.
And my lawyer's gonna be coming here.
I don't know. He's not here yet, so hopefully he shows up. Can you file no contact and no weapons on those, please?
Sorry, was that pretrial bond conditions?
No, just state no contact, no weapons. Good morning, Mr. Huggins. So understand that your lawyer is here because he wants me to set you a bond. I don't know. I don't know anything about you. I've never met you before. I know that you're going to tell me it's little bunnies jumping in the woods, but really, what matters to me are two things. Number one, what are you charged with? Are you a dangerous person? And more importantly, most importantly, are you going to go back to the demanding jurisdiction? I have no idea. We have to get to know you in the short time now, 20 seconds, just to see who you are. So, Mr. Kim, tell me about it.
Yes, Judge. Defendant is wanted at East Baton Rouge Parish, Louisiana for a domestic abuse, battery, strangulation, or equivalent of impeding breath. State would be opposed to bond. Defendant is currently on deferred adjudication for aggravated robbery, where he was the driver and there was a firearm involved. During the aggravated robbery deferred, he picked up a misdemeanor possession of marijuana, which alone, that wouldn't be sufficient to bring up the court. But the fact that one of his conditions on his deferred adjudication was to not consume any marijuana, he violated said provisions, and then now he picks up a strangulation. The warrant was 10 days old when he.
So this is this case here, this is a new case?
Yes, Judge. It was issued out January 14th. And so because of the repeated violations, the offense being one of them, the state would be opposed to bond.
If I may, Your Honor.
Please.
Mr. Huggins has already retained counsel for the New Orleans case. Eric Hayes, I have been in communication with him. I think it's important for the court to know, as it relates to the allegations out of Baton Rouge, that it was actually the complaining witness mother who hired us to be here this morning on behalf of Mr. Huggins. I also think it's important for the court to know, even though it is triable facts for the Louisiana case, she also sent us over several videos. We're confident that he will appear in New Orleans because he's already retained counsel. We believe that he won't have a problem complying with all of the things that's been outlined here in Harris County, seeing that he does have strong ties to the community and he is employed. And because of that, Your Honor, we do believe that there are conditions that can be put in place if the court elects to give him a bond, such as an ankle monitor, to ensure that, one, the court knows where he is and that the community is safe. And then also he has already retained counsel, Mr. Eric Hayes, for that matter, out in Baton Rouge. So I believe I have no reason to believe he won't answer to Baton Rouge, and I don't have any reason to believe he won't comport with the conditions here in Harris.
You're a dangerous person, man. How old is he? 22, 23?
Yes, Judge. And to add, for what it's worth, he already had a GPS ankle monitor as a condition of his deferred when the strangulation happened, or at least according to the conditions. And
Was he not supposed to go there too?
No, it's just one of the arguments made by counsel was to have a GPS monitor secure.
This is that, it's such a short time. He's picked up this case. He picked up, I guess, a weed case, and he's on probation for an aggravated robbery. I mean, really.
Full disclosure, there was a motion to adjudicate, but in the Brenham case that was dismissed. I don't have the files for the Brenham one, but I presume because the deferred was cured that they didn't pursue it. But he was only charged and it was later dismissed, but it was 2023. So obviously very recent.
Let me ask you this. Is he on bond for did they file a motion to adjudicate on the
aggravated robbery, but then that was dismissed on October 16th.
So he has no holds now, right?
Currently, yes, Judge.
And it was dismissed because the Brenham marijuana case was ultimately dismissed.
Yes.
I'm not comfortable giving you a bond now, Mr. Huggins. I think you're a dangerous person, man. You picked up that case over there. You're on probation for an aggravated robbery where there's a gun, and I don't know if there's shooting involved, but the good news is that it's only Louisiana. We have buses coming in and out probably 2 times a week to take people back because we have so many people from Louisiana here. So once you waive extradition, Monday, Tuesday, you'll be back in Louisiana. So he's not going to be sitting for not too long. I don't feel comfortable doing it, man. You scare me, dude. So you said he has waived, right?
Yes, Judge.
Sorry, counsel. But the good news is that he'll be back lickety split, and Was it Lafayette?
It's East Baton Rouge,
East Baton
and
Rouge.
currently the aggravated robbery doesn't have a new MAJ based on the impeding or the strangulation, and so I can't speak for the trial bureau, but if they decide to revoke.
Jogging, you gotta understand, when you're on felony probation, something like that, you gotta live with a halo on your head. Cause you could be looking at 20 years, man. All right.
Thank you,
Thanks.
Your Honor.
Thank you, Judge.
Thank you.
Yes, sir. Come on, Mr. Akers.
This one here, let's see.
Why does this continue to happen? The peeling.
Segment has adverse effects on my body. Yeah, if I'm stepping down now, it's gonna be on
How many times have you switched medications?
the medication since I was 12.
No. Now, how many times have you switched your medications? You're telling me it's an adverse effect of the medication that you're peeling your face.
Oh, pin my face. No, that's I missed that part. It's working on spotted fever.
It's what?
Working on spotted fever.
So, Your Honor, he's diagnosed with schizophrenia. Of all defendants, there are active symptoms of use disorder. There's a delusion that he has some kind of parasites under his skin. We hospitalized him with an NPC. That NPC uses medication. They do prescribe medication, comes back, uses to take the medication, continues to scratch, gets blood all over the place. Other clients are complaining. Using a program, continually tells me I don't want to be in the program, nothing wrong with me. I don't feel anything about it.
They consider it a delusion. This is an actual medical condition, talking about spotted fever, and they want to call it a delusion. But
If you take the medication, things will start going well.
This for mental conditions, for the schizophrenia, that has nothing to do with the actual medical condition. They're denying any medical, anything medical to do with this. They want to make it out like it's all mental.
Mr. Akers.
It was the problem I was having when I come in here and you're standing up there, you wouldn't let me speak, and you say you're rotting.
I'm trying to prevent you from killing yourself. You're doing it slowly. And I've seen the deterioration that has happened in the last 2 years that you've been with me. And it's not going well. All they're trying to do is help you. And by taking the medication, that's what's going to happen. When you don't, that's when everything starts happening again.
That has nothing to do with the medical part of it. I've been on social disability since 2002.
How do we get you to take the medication?
I would take it. He lost two. I left my ex-wife. I left Missouri. I lost 200 pounds, and I've lived my best life since I've been off the medication. I told the lawyer before I went there. I said I'll do fine if they don't try to force me to take medication. I went there. The psychologist said, I'll give you a sleeping pill, melatonin, PRN. That's all he gave me. And the nurses, they're bulldogged me until they kept bringing me back in front of the psychologist, making stuff up until they were prescribing me. They sent me to the hospital twice. I come back from the hospital with no medication. I got back, the nurses bulldogged.
He's on probation right now, right? If you are not in compliance with your probation, then it's very possible a motion to revoke gets filed.
Yeah, that's fine with me. I'd rather just do my time.
So let's do this. Take a seat for me. I'm going to appoint your lawyer. I need to appoint a lawyer. I don't know yet. Let me.
Did you want to revoke on bond condition violation or new law violation?
New law violation.
New law violation.
Yes.
Yes.
Hey, Ms. Donaldson. Ms. Donaldson.
Yes, Judge. We're coming to order.
Hey, this letter's great. I've never seen this one that you just gave us. I mean, this says it's to notify you that Joshua Hunt was admitted to Woodland Springs Hospital on 110. This is great.
Okay, perfect.
I mean, don't you think this tells us that he's been admitted, right?
Yes.
I mean,
Need the noise to go down.
do you have a point of contact for him, like mom or who?
Yes, Mom.
Okay, so I guess now let's set it off a couple weeks. If you can just please reach out to mom and let her know, hey, we need to know when he's discharged, so that we can have him come up and finalize the thing, I guess, once and for all.
Okay, yeah, I could do that.
Yeah, just keep me in the loop and then just whatever day you want, we'll get, 2-3 weeks. Just keep us in the loop.
Understood. I could do that, Judge.
Yeah, all right. Well, thank you so much and good luck to your grandfather, huh?
Thank you.
Just want to stop by and say
You're welcome.
If you need to talk, step out. No phone, step out.
Thank you. Thank you.
Judge, can you sign a moment for,
Yeah, I'm signing everything, right?
Where? Yeah. Come around. Price? Court's on the order. Why you come on up?
That's right.
Your belongings right here. Your permit.
Like you were charged with driving while intoxicated, second offense. You were facing up to a year in jail and or $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 18th, 2025, the officer observed the defendant's vehicle stopped and impeding the moving lane of traffic, with other vehicles having to honk and go around on the 2300 block of Bagby Street. The officer honked and used sirens multiple times to get the driver's attention, but the defendant chose to ignore him even after the passenger advised the defendant that the officer was attempting to get her attention. A traffic stop was then conducted, and the officer observed slurred speech, glossy eyes, and a strong odor of alcoholic beverage. The defendant admitted she drank 2 beers while at a memorial in downtown area, and the officer had the defendant exit the vehicle and observed unsteadiness on her feet. The defendant refused to answer anything else and was uncooperative on the scene. At JPC, center filtered writings were conducted, HGN 6 out of 6, walk and turns 7 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused breath. A blood search warrant was signed and executed.
And I'm going to find that there's probable cause to go forward with your case. You have a valid Texas driver license.
It's eligible, Your Honor.
I am now placing a restriction on your license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, you will go to jail because I will revoke your bond. You're also not to consume,
Whitaker, or step outside and you talk.
not to consume alcohol, illegal drugs, or unprescribed controlled medication. And I'm going to randomly test you. If I find that you're using, likewise, you will go to jail, ma'am. I'm sending information to DPS so that every single officer in this state will know if you get pulled over, they will know that you're to have an interlock in your car. So if you're caught driving a vehicle that doesn't have one, they will take you to jail. You understand, ma'am? Do you have the ability to hire a lawyer or would you like a court-appointed lawyer, ma'am? Sorry? You're going to hire a lawyer. Okay. So what we'll do now is I'm going to have you sign a receipt with Victoria. We'll have you meet with Felicia for your bond conditions. After that, we'll get you out of here. And then when you come back, please have a lawyer. Okay.
Right this way.
Alex, come on up. You know, all I want to do is just keep him from killing himself. But I mean, it's just not going to just keep him from killing himself because
Mariah Williams.
he's so tweaked out. I mean, it just, you can see how just, right. No, you're right. You can lead a horse, right? As they say. So I guess, come up, Mr. Akers. You know, there is an adage, a saying that goes, you can lead a horse to water, but you can't force him to drink. This is exactly what's going on here. I've been trying to get you help and you just refuse to take it. But what's going on now and what they're alleging, how you're, I guess, are you saying he's peeling his face and putting blood on places? That's just unacceptable. And all we want to do is prevent you from killing yourself. When you come in here with new cases, I see the way you are, and it's not good. And I mean, who am I to try to help you if you don't want to help yourself? So if you want me to cut you loose today, I'm going to do it. But you can only treat your body this way for so long before your body just explodes on itself. It's just a matter of time. I don't want you to say anything. I want you to think, because the idea is that you get help in whichever way that you can, because the way that you're treating your body, it's going to come back on you. You can't live like this forever. You get older and your body worsens with age. It doesn't get better. When you get out there and you're out there in the free world, think before you act. Think before you speak, because every time you come here with a new case, it's not going to go well. If you ever want help, all you have to do is come back and I will get you whatever you need. If you want a cell phone, if you want a tablet, if you need medication, whatever you may need. But living the way that you are, you start using dope on top of it, your meth or whatever it may be, all you're doing is making things so much worse. If you don't want the help, I'll just cut you loose today. Just tell me what you want. You're old enough to make your own decisions, and I will do whatever you want. But if you don't want it, I'm not going to force it on you.
I'd like to go. The horse, you lead it to the water, but you can't make it drink. It comes from running a horse so hard that once you get it to water, it's too tired to drink water to save its life. I understand what you're saying.
It's always a way, Mr. Akers.
Lesson learned.
Actions speak louder than words. So we will see. I'll cut you loose today if you want it, but you come back, it's really not going to go well. Do you understand? Okay. So you let me know whatever you guys want to do. If he wants to unsat term, I'll do it today. And then, yeah. So I'll let you speak with counsel. You let me know what you want to do.
Thank you, Judge.
Yes, ma'am.
Judge, I got appointed to Mr. Richard today. It's RICHERT.
Yeah.
And he has no contact as part of his conditions in a MOAB. He does have 2 daughters with the complainant.
Court comes to order. He talked about.
He wants to know if he can still go there for visitation
No, she doesn't want him to come over. That's what I heard. Right.
Well, Judge, would you at least allow him to get a third party to pick up the daughters?
I mean, come up.
Maybe we could do that as sort of a middle ground.
Is it Richard or is it Reichert?
Richard.
Mr. Richard, I like to follow the wishes of the complaining witness. So if she doesn't want to have contact with you, then that's what we do. If she wants to have contact with you, then I'm fine with it. But I have to hear it from them to see what they want. Okay. What the state has told me so far is that this person doesn't want to have contact with you. The last thing I want is for you to go over there, you accidentally bump into her, words exchange, you're the one that's on bond, you're the one that's gonna end up going back to jail. So it's more of like a preventative measure, right? So there's no issue if you have someone else to try to facilitate contact with your daughter. The complaining witness is only the ex-wife. It's none of the daughters, right?
Correct, Your Honor.
Right. So however you want to have contact with the daughters, great. Just don't go over there. You can always use someone else to try to like be an intermediary to get them to you however you want. So someone else could go pick up my children and bring them to you? Sure, of course. Yeah. But that's probably the safest way so you don't bump into this person. She says something to you where it just inflames the passion and, you know, that's the last thing we want.
Is someone going to explain to her that someone else will be picking up my children? If I'm not allowed to
I guess,
contact her?
can you reach out to her and let her know that that's what we're going to try, that's what they're going to try to do so that she's aware of, you know, even leaving however you want to. Yeah, we'll have the state reach out to her to let her know that this is how we're going to, the agreement that they're going to try to work so to have someone. How old are the daughters?
8 and 14.
Yeah. Yeah, do you mind, please? Yeah, okay, so they'll reach out and do that and then, you know, hope maybe a grandparent or someone else or.
They're worse.
Yeah, okay, well.
Thank you, Judge. I appreciate it.
For sure. Anna,
I have to talk to you about today.
okay.
The first one, Rodriguez.
Do you mind bringing out Mr. Rodriguez, please? Who's your second one?
Torrance. She's on bond.
Come up, Ms. Torrance.
Let's see.
This is a second bond violation, right?
I believe so. I'm trying to remember the first. I think the first one was
There was one that was filed in October where she failed to go to take a drug test at the facility. She was called upon to do it.
Okay.
And now we have it where she has a portable device and she's skipping tests.
Yes.
So, I mean, I'm trying everything in my power not to put you in custody. Go ahead.
If you would like to have a hearing on the bond violations to revoke it, let us know when you want to do that so we can get somebody.
But Monday,
Okay,
but Monday.
okay.
I'm gonna have a hearing as to whether I'm gonna revoke your bond. I mean, if they prove to me that you're skipping tests, then, you know, it's not good. So let's roll it to Monday. We'll have a full-blown hearing. We'll go from there. Okay, sure.
A bond revocation hearing. Okay. Can Ms. Torrance be excused?
See,
In the petition.
if you can get her the report as far as the violations or as far as the skipping,
I'll get those.
please. Ramirez?
Rodriguez.
Rodriguez.
Okay.
All right. Good morning, Mr. Rodriguez. So, well, great. Thanks. It's Friday, finally. Friday. It's come to my attention that you've picked up a couple new cases while you're on bond. So state's asking me, or I guess, what are you asking for, state?
We were asking for 5,000 on each of the cases.
To revoke the bonds?
Yes, sir.
On which cases?
On, one moment, the criminal mischief and the assault bodily injury.
Okay. And that is because he's picked up a new criminal trespass.
Yes, sir.
Did you say that there was one that you were going to have indicted too?
Yes, sir. And we're pending on the offense report for that still at this time. So we're waiting for a new date.
What is that?
What is that case?
Yeah, what is that? Is it another trespass? Is it a theft?
Assault bodily injury.
Oh, there's another assault.
Yes, sir.
Did you know about this?
Yes, because that one was no PC by the magistrate when all of these cases came to the court. But it was no PC because they, I think fat fingered the date of the offense as 2021, not 2024. And so it was outside the statute of limitations when it went before the
Someone
magistrate.
accidentally put 2021 on the actual report instead of
And
24.
yes, my understanding is that the state is having to get a copy of the offense report and then they can take it to the grand jury with the correct date.
Okay. So what is your response as far as the mischief and the assault on the bond revocation?
We're in agreement with the 5,000.
Okay.
He has a case upstairs, so.
Oh, I see. Right. You have a felony case. So, all right. So on the mischief and then the assault, if we can put it at now 1, 2.
Judge Jackson had previously revoked the ABI when they were last week.
Yeah, but I think they're all in agreement. So we'll do 5,000 and 2, 4.
5,000.
Yeah, on the assault and the mischief. Right. We'll leave the trespass as is. Right. So Mr. Rodriguez, what's happening now is I'm going to revoke the bond on your 2 older cases due to the fact that you continue to pick up other new cases. You can't expect.
Right. Yes,
Right. So,
Just for clarification, the case that's being taken to the grand jury, that's already kind of accounted for in the 5,000. There's not going to be a new BVR when that.
Right.
Okay,
What do you?
I'll defer to you on that, Your Honor.
Okay.
Okay.
I'm okay with that.
Okay.
Right. I'm not going to just be duplicitous to kind of just then revoke it again.
Okay, I just want to make sure we're all on the same
So
page.
what do we set it at when we actually do get it?
The ABI,
Yeah, the new one.
To be completely candid, Judge, I don't know that it really matters because 1,000 or 11 billion thousand, it's.
Yeah, I guess we'll cross that bridge when we get there, whenever they do get it done. Yeah, okay. All right, so if you do bond out, I'm going to put a GPS monitor. I don't know if you're going to get out or not, but I'm ordering you not to have any contact with the complaining witnesses in these cases, not to be in possession of weapons, and I'm going to put a monitor on you so I know that you're not going over there. The monitor will go on you prior to your release from custody if you are able to make bond.
Yes, Your Honor.
Do you understand? Do you have any questions?
No, Your Honor.
Okay, man. Good luck, Mr. Rodriguez. So we need him to sign before he goes, please.
Thank you.
Thanks, guys.
Are you excused?
Yes.
Just come over here, Mr. Rodriguez.
Ms. Hassan, come up.
And so what we're gonna request is obviously a reset to be able to speak to the appropriate person. Ms. Geis, I believe, is in charge. Right.
Has she already been booted out?
No, this is the initial, they always,
Everything didn't have to hold the PTR program, she would. But because I guess everybody is in limbo, they're just waiting.
What violations do we have?
218 is a lot. She's averaging 14 to 34 skip tests a month on her device. She tested positive for THC. She's failed to report for her office visits on the September 24th, October 8th, December 3rd, December 31st, and January 8th.
Can I?
Nope.
so obviously.
Actions speak.
Yeah,
Right.
but
Stop,
Your Honor.
stop. Don't. Got a lawyer.
I'm just passionate about this. If I could, Judge, we would just request a reset. Let me get all the.
So, but I'm now going to put an ankle monitor on her so I know that she's not consuming. I'll pay for it.
Did you fly here?
I did fly.
Did she fly on an airplane with that?
I would assume so. But she's on bond in this court. She's skipping tests that she's not supposed to be doing. I'm putting a scram monitor on you. That's it.
I do have an answer.
Guys, you talk over there. You're on bond in this court.
Okay, and I will travel as well with the monitor, but I did have an issue last time I came with the DUI machine. It stopped working because I traveled out of state and I was ordered to pay a whole new device, turn it in, and I had to wait a whole week without testing because of that problem. So I just don't want to run into that same problem with the ankle monitor.
So when you have issues, you're supposed to contact the provider immediately and let them know, hey, I've got an issue. You go to where they are, right? And there are devices that you can, they're global. You can go all over the globe. They use, Wi-Fi or whatnot, so that it doesn't matter where you are. You can be in Abu Dhabi, you're still able to use the device, and the device can go internationally. There's just, if you know that that's a lifestyle you have, that's the kind of machine that you get. So regardless, I'll give you, the case is 400 days. I will give you some time, right? Tell me, how much time do you want?
I don't know, like 3 or so weeks,
Done.
because everything else in the way, but, and then can we wait for appearance, the next setting?
Well, I don't know yet, because if they deny it, then we need to figure out what we're gonna do.
Figure something out. Yeah.
So,
Like she and I haven't really had the time to sit down and just really go through, obviously she's very passionate about what happened and.
so amending your bond conditions, you will get a scram ankle monitor now. If I find that you're consuming alcohol, and I don't care what it is, I don't care if it's mouthwash, I don't care if it's a tequila lollipop, I'm gonna revoke your bond. Do you understand?
Yeah.
Can you run her license to see if she has a license?
Yes, Judge, I'll run it right now.
Today,
At what time?
later in the evening, like around 6, 7.
So Judge, her flight leaves today at 6 p.m.
She's gonna go now. We'll get her in now.
Get it done
Right now.
Okay, right.
Your Honor, it appears to be a valid California license.
As long as you have a valid license and liability insurance, then you can drive unless, well, no, you're not allowed to drive without an interlock. So you have to have the interlock.
I'm not driving right now.
I'm just telling you what
Okay.
the expectation is, so that, I don't want to have to revoke your bond. You have to know what the expectations are. Now, okay, so we'll give you whatever time you want. At the next setting, because your case is old and because of their violations, I'm not waiving your appearance anymore. If you get her back in to the program, I guess at that point, we don't leave her here, right? I'll waive it. But if it's denied, then she's got to come back here so we can resolve it one way or the other.
Okay, I'll just file a date for it.
Just let me know. Yeah. Okay. All right, man. Good luck.
Chavez, come on up.
Yes.
When we had the printed docket, it was missing the first 2 pages.
1 minute, I'm almost done.
You are Raul Chavez. Mr. Chavez, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 15th, 2025, officers are dispatched to a family disturbance. Officers were dispatched to a family disturbance, and upon arrival, the officers met with the complainant, who stated that she and the defendant started arguing over the defendant, accusing the complainant of cheating on him. The defendant stated that the defendant grabbed the complainant by her hair and pulled her to the ground, causing pain. The defendant then wrapped his arms around her neck and later struck the complainant several times in the stomach. The defendant admitted to wrapping his arms around the complainant's neck for approximately 3 seconds.
Mr. Chavez, I'm going to find that there's probable cause to go forward with the case.
Right. Right.
It looks like a protective order has been issued in this case. I would get to know it. If you violate this protective order, the state can, possibly will file a violation of a protective order against you. It's one of the worst cases you can pick up. I am ordering you also not to have any contact with this person and not to be in possession of weapons. If you violate this, I will put you in jail by revoking your bond. Do you understand?
Yes, I do.
Can you file no contact and no weapons, please, Alex? Did you need a court-appointed lawyer, Mr. Chavez?
I thought I did have one. I already spoke with someone. I think his last name was Torres.
You don't have a court-appointed lawyer. Do you want one?
When I was in jail.
It's just.
That was for magistration purposes only.
I do need one.
Okay, we'll appoint your lawyer today. I've got an affidavit already on file. All right, just take a seat for me. Do not leave until you sign our bond conditions and then after you've spoken to a lawyer. Okay? Take a seat.
Right this way.
Oh, wait. No, he needs to sign a reset first.
The next one is page 8, Delgado. Come on up.
We have two more or one more after that? How many more after this one?
2 altogether, 2 more after this one.
Okay.
This is the one we had traveling.
Oh, I think it's, sorry, Judge, page 7, Corral. All right, have a seat in the jury box.
Morning, Judge.
Mr. Corral, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 18th, 2024, officers were dispatched to a family assault and made contact with the complainant, who stated that she and the defendant are dating. The complainant stated that they got into an argument when the defendant grabbed the complainant's arm and squeezed, causing pain. Complainant stated she punched and struck the defendant to get away. The complainant stated that the day prior they had gotten into an argument and the defendant grabbed her by the arm and squeezed while the complainant fought to get away. The officer observed bruises on the complainant's arm.
Got it. Mr. Corral, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate these conditions, I'm going to put you in jail by revoking your bond. Do you understand? I don't see a protective order that's been issued. Has one been issued in this case?
I see it as of 1019, Judge.
No, but it's not been signed. Corral. Yeah. Do you guys see it or no?
That's fine.
All right, Mr. Corral, I'm entering in what's called a mattress order of emergency protection that identifies Ms. Cabrera as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the East Tex Freeway Apartment 4304. If you violate this court order, the state can and will file additional charges against you, including a violation of protective order. It's one of the worst cases you can pick up. So know what you can and can't do before you leave this place. Do you need a court-appointed lawyer, Mr. Corral? Okay, I'll appoint your lawyer today. Do not leave until you sign all our bond conditions. Otherwise, a warrant will issue. Please.
You can come up here and sign this tomorrow.
You are Dennis Fisher.
Sir.
Mr. Fisher, you're charged with discharging a firearm in a metropolitan area. You're facing up to a year in jail and or a $4,000 fine. This case is super old. Every time you take off, every time you go, we revoke your bond and just raise it. And all you're doing is you're giving away free money to bonding companies every single time. Do you have a lawyer today?
No, sir. No, sir.
Okay, would you like me to appoint you one? I'm going to appoint you one, and I'm going to tell you now, you take off on me again, I'm going to make your bond so high, you're going to not know what to do with yourself. Do you understand? Okay. Reaching out to the MAC for Mr. Fisher as well, please. Okay, I am ordering you as a condition of your bond not to be in possession of any weapons whatsoever. You understand? Okay, do you mind filing that, please? All right, just take a seat. We'll have you sign a reset and we'll have you take a seat in the jury box. Okay, JP.
They're working hard, Judge. Can we approach on Mr. Gibson?
Absolutely.
So I spoke with the complainant. So I spoke with the complainant's daughter because the complainant doesn't really speak English, and they gave her number purposefully as a contact to reach out to. I spoke to her about the letter that defense counsel sent to me and they had sent to the defendant. They said that they would be okay with him coming to pick up the car.
That's it.
But that's it. Otherwise, they want no contact.
So
obviously though, Judge, I mean, there's a little dicey because they sent him a letter. He's got to pick up a vehicle. I just don't want him.
So what we'll do is I'm going to craft bond conditions that he's got 3 days to go pick up this car.
Okay.
After that, he's not allowed to go back to this place. He can only go there one time to pick up the car. That's it. If they, please, I want you to let them know if he's there multiple times, his bond gets revoked. One time he goes there and get the car and get out ski.
Yes, Judge. I anticipate no problems, but I mean, there's obviously might be some contact that might have to happen for him to
get there on his vehicle.
Come on, Mr. Gibson. Let's figure out.
If he's gotta go again, I mean, there could be some.
Where's the car?
It's, honestly, they've been withholding my property.
It's not, we're not
I don't know
doing,
where the car is. I haven't been there. I'm not in the videos, so.
Just speak to the marshal. I'll handle it.
Okay, yes, I don't know where
I'm
the
asking
car.
you one question.
I received an email that the car is at the property. I don't know. I haven't been there.
So there must be some contact to. Hey,
No,
where's
no,
the
no,
car?
no, no. Can you call her back right now? Ask her where the car is, please,
Yes,
real
I
quick?
can call her back. It seems, I would need to take a look at the email again, but I would think that there would be something in there to.
Why, let's not assume.
Right.
It's so easy to just make real quick another phone call, you know? I mean, she answered for
Yeah.
you now, real quick, try, say, hey, where's the car? How can we get this to him so you don't have to talk to them?
Okay.
You know, the best way is to like really micromanage it so that he doesn't have to go and talk to them and then there's more bad blood and then he gets arrested again.
Understood, Judge.
Quick,
Yeah.
2 minutes?
Okay.
Hang tight.
I'm not sure you got
I put it on for Monday because that's when we're doing
So we're rolling from today to Monday?
it. Correct.
Can we make sure? Thank you.
Yes. Are you ready?
Yes, just can we replace something? Give some. From the.
All right.
I spoke with her again. She said that she needed to reach out to her dad and brother to see a time that would work for him to come.
Where is the car?
The
Where?
car is at the property at,
Is it in the like, you know, apartment complexes have outlying lots. They have lots that are inside of a gate. You need a code to get in to get the car. She didn't say where the car is?
I know the address of where the car is. I don't know exactly what type of property it is.
Can we do an in run around this, Judge? If you'll allow exemption for me to do all the, middlemanning, I'll just go and pick up the vehicle. I'll get it. I'll talk to them and
Okay.
get it somewhere.
And you're an officer of the court. I trust you. You know, find out where the car is exactly so he knows exactly where to go get it. Hopefully, it's not in a complicated place where he's going to have to talk to them because I don't want him to talk to them.
Of course, I won't be communicating with them about anything from him, just for him to get it.
So let them know that he's not to talk to them. If he goes and tries to talk to them, I'm putting him in jail, right?
Yes, Judge.
Just to get the car, that's it, and get the middleman, right? Yeah, of course you can. I mean, you're the go-between.
Yes, Judge.
Okay.
Okay,
Thank you, Your Honor.
for sure.
Will we need to redraft that? Just finish on.
Let me see what it says. Hold on.
But technically, if I'm doing it, I guess it's still no contact.
So what I'm going to do is I'm going to edit this to say this. It says, do we know what day he wants to go back?
I don't know, I'll have to sort all that. That's why I'm saying there's gonna be some contact about, is there a gate code? Where is it? When? So I need to,
Because he's got 3 days from the date of that letter, right? When was that letter?
I think it said until the 25th.
Just remind me.
Okay, so I'm gonna put here, defendant has until 1:25 to go get his car from the above listed address. Defendant is not to have any contact with the complaining witnesses and no weapons as well. So he's going to be the middleman to figure out where that car is for you to get it. You get it and you go. Don't dilly dally. Don't try to talk to them. If someone comes, just get it and go. Make sure you have everything with you. They're probably going to maybe want insurance. Don't bring an insurance card. You know, it's like when you go pick up your card at your car at like an impound lot. You need your insurance card. If you don't have insurance, they're not going to give it to you. Make sure you come with the keys. You've got your insurance card, everything so that you know. You understand?
Yes, sir.
Okay. All right. We'll have you sign this. So you know what you can and can't do.
Yes, sir.
All right. Okay, good. Come up, sign it. We'll let you go.
Thank you.
Okay. And thank you,
Thank you for your patience.
JP. No, thank you. You're doing great. Hey, I need you, Matt, we need to do work on homeboy. You ready?
What are we gonna do?
Yeah, he picked up a new case while he's on bond.
Oh, I thought they were filed.
No. Come up, sir.
Well, does that mean what I think it means?
Well, I don't know. We haven't done PC yet. We got to do PC. This is Mr. Jones, right?
Yes. Mr. Jones, you had two.
Judge,
You were-
I don't think it was that he picked up a new case. It was just that they were separated.
No. One, we have an assault from September of 24, and he picked up a DWI January 19th,
When was the assault filed?
right?
It's not Jones, Judge.
Yeah.
Assaults filed September 10th, and then the DWI filed January 19th.
Judge, it was an open room for a long time. Bond was never closed in.
So the 2B gets filed September 10th of 24. KPS issues on the 12th. Yeah, I guess you're right. So, Mr. Jones, you're charged with two cases. You're charged with driving while intoxicated. You're also charged with assault of a family member. On the assault case, you're facing up to a year in jail and or a $4,000 fine. On the DWI, you're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On which case, Your Honor?
Both. We have to do both. Dealer's choice.
Yes, Judge. So on them on June 24th, 2024, officers were dispatched to a disturbance. The complainant and the defendant were in a verbal argument over his driving, and the defendant continuously made threatening remarks to the complainant until they arrived at their apartment. The complainant locked herself in her bedroom, and the defendant kicked in the door. The complainant tried to flee the apartment, and the defendant grabbed a kitchen table chair, lifted it above his head, and slammed it on the complainant's head, causing pain.
Gosh.
The officers observed the complainant had open wounds on her right pinky finger, the inside of her right forearm, and her upper neck chin area. And then on the DWI, on January 18th, 2025, the officer was dispatched to a traffic hazard on Airport Boulevard in Harris County, Texas. The officer met with a wheel witness who said he was driving when he saw a truck that was stopped and turning off in a moving lane. The wheel witness went to the truck and saw empty beer cans in the bed and the defendant in the driver's seat. The wheel witness said the defendant appeared to be intoxicated, so he called police. The officers made contact with the defendant and noticed an odor of an alcoholic beverage, watery red bloodshot eyes, and slurred speech. The officer asked the defendant to step out of the truck and noticed the defendant was swaying. The defendant said he was coming from his mom's house and had two 12-ounce beers prior to driving. The defendant refused to participate in center-field sobriety tests. The defendant was read the DIC and refused to provide a sample. A blood search warrant was signed and executed.
Is there alcohol in the car while he's driving?
No, Your Honor.
And Judge, if you look at his eyes now, his eyes are red. I think that's more of a medical condition than anything.
As far as the assault is concerned, he had an assault that was dismissed in 23. Is this the same complaining witness, Alex?
Yes, Judge.
Mr. Jones, there's a protective order that has been issued in this case. I would get to know it. If you violate said protective order, the state can and will probably file a violation of protective order. That is the capital murder of misdemeanors. Do you understand? It's one of the worst cases that you can pick up. I am ordering you as a condition of your bond not to have any contact with this person whatsoever, not to be in possession of any weapons. I'm also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, you will go to jail. No more PR bonds. Do you understand? Any prior DWIs, can you run a full MCIC, please? And does he
Yes,
have
Judge.
an
And
does he
there's no prior DWIs.
Texas driver license?
Yeah, I'll run that right now, Your Honor.
Please.
Your Honor, the driver's license says eligible in our system.
Okay. Like I said, you're not to have any contact with the complaining witness in this case. I don't care if she calls you, you have contact with this person, then I'm going to put you in jail. If she calls you, do not answer the phone. If she calls you from an unknown number, you hang up the phone. If she texts you, do not reply. If she comes to your house or wherever you may live, don't answer the door. But if I find that you have any contact with this person, it's just not going to go well for you. I've given you a lawyer. It is your responsibility to stay in touch with Mr. Perez. He will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, likewise, a warrant will issue for your arrest. I'm going to do everything in my power to protect this community. in every single way. Do you understand? Okay, all right.
Thank you, Judge.
Goes with you.
That's fine. Okay, so just a second.
All right, I think we're done after that, though, right?
Yeah, so I believe the magistrate.
Well, ladies and gentlemen, it's another Saturday in the books. I've got to say thank you very much to Rahul and Dark Knight out there for their super chats. That was super cool. I do appreciate y'all very much. Kids, it's been a great live show. Your comments have been the best, as always. Keep a lookout. I'll probably be breaking these out as into their own individual little videos. I'm going to break the Fleischer Forum out into its own special video to go into the Judge Fleischer playlist. So, if you want to rewatch that, keep an eye out for it. It'll be out there. Ladies and gentlemen, I'm your Lone Wolf Usul. I'm your host for these here videos. I'm your curator and guy in charge for the live shows that happen every weekend. Saturday, 11 a.m. Central Standard Time, 12 p.m. Eastern Time. And keep an eye out for more videos all week long. I'll be seeing you guys in the funny papers. Come back next week. There'll be a lot more to go. There's a lot that stays on the cutting room floor, and this is where we get to see it, basically. Ladies and gentlemen, we'll see y'all next time. Keep an eye out for the Fleischer Forum every weeknight that Fleischer is live. I will be putting together a Fleischer Forum, and we'll either be doing it live or we'll be premiering it so we can have a live chat alongside with it, unless I mess it up like I did last night. And then we'll figure out something else to do, just like we did today. Stay safe, everybody. See y'all next time. I'm your Lone Wolf Usul. I'm out.